It's 12:01 p.m. The Committee on Judiciary and Civil Jurisprudence will come to order. The clerk will call the roll.
Leach,
Here.
Johnson, Dutton,
Here.
Moody, Landgraf,
Here.
Schofield,
Here.
Gonzalez, Flores, Hayes, LaHood,
Here.
Dyson. Quorum's present.
Okay, quorum is present. The chair lays out House Bill 2176 and recognizes Chairman Harless to explain the bill. The chair lays out the committee substitute to House Bill 2176.
Thank you, Mr. Chairman and members. This is simply a cleanup bill. The local court administrative judge in a county is required to have a security committee, and all this does is add a JP to that committee, one JP from the county, one constable from the county. And it requires them to meet once a year. The other thing this bill does, lastly, it clarifies that a court security committee is not considered a government body as defined under section 551.001 and 552.003 of the government code. Stakeholders were concerned that the security committee, as defined as a government body, and the county didn't want the security recommendations being ignored. And lastly, that takes care of that. We do have some expert witnesses, but it's strictly a cleanup bill.
Okay.
Just adding a JP and how often they meet once a year.
All right, thank you, Chairman. Members, any questions? All
I
right.
reserve my right to close, and thank you for the opportunity.
Yes, sir, thank you. There are two witnesses registered to testify for the bill. The chair calls Larry Gallardo, is that right? Okay, and Holly Williamson. Thanks for your patience and for sticking around. Ms. Williamson, let's start with you. I've got you registered. Judge Williamson, Justice of the Peace and Constables Association of Texas for the bill. Is that correct?
That's correct.
Okay, go ahead.
Thank you, Chairman and members of the committee. My name is Holly Williamson. I serve as a Justice of the Peace in Harris County, Texas, as well as President of the Justices of the Peace and Constables Association. I'm here today to express our strong support for this bill as authored by Chairman Harless. The statistics that I bring before you today are shocking and cannot be ignored. In fiscal year 2024, according to the Office of Court Administration, Texas courts reported an alarming 1,080 security incidences, marking an increase of over 140% from the previous years. This is not just a number. It represents real threats and dangers that our judicial system and the public face daily. These incidents encompass a wide range of security threats, including over 580 weapons that were seized at courthouses, weapons being brought into courtrooms, raising the stakes for everyone that's present. Over 150 disorderly conduct incidences, undermining the decorum and respect that our courts demand. Over 140 direct threats, individuals feeling emboldened to intimidate judges, court personnel, and the public. These incidents create a climate of fear, making it difficult for courts to function effectively and safely. There's also been reported active shooter situations. These threats are not just hypothetical, they are ever-present reality in today's courts. The Court Security Act, Senate Bill 42, enacted in 2017, laid the groundwork for addressing these concerns. But the dramatic rise in incidents since then illustrates that we must do more. Justices of the peace courts are often housed in annexes, strip malls, and buildings that the community is accessible to the public, but with little or no security. This bill is a crucial step forward in strengthening our court security measures by providing necessary stakeholders, justices of the peace, and constables to the Court Security Committee to protect everyone who enters our courtrooms, all the courtrooms in Texas. As a Justice of the Peace, I witnessed firsthand the challenges that we face in maintaining a safe environment for both court staff and the public, and the safety of our courts is not just a concern for those who work within them, but it's a public safety that affects every Texan. So I urge you to support this bill, to take decisive action and make a meaningful difference in the security of our Texas courts and the judicial system. I thank you for your attention and consideration of this bill, and I certainly will answer any questions.
Thank you, Judge. Great testimony. Appreciate it. Members, any questions for Judge Williamson? Yes, Chairman Dutton.
Thank you. I was just, when you said you needed protection in the courts, I wondered why is there really a sound basis for excluding municipal courts?
That's a great question, Chairman. In the bill, municipal courts are included separately. So every municipal court in the state of Texas does have a court security committee. I actually serve as a presiding judge of a municipal court. And so the municipal courts are handled in a separate part of that SB 42 from 2017.
Which is why they're excluded here.
That's why they're excluded here,
Yeah,
correct?
that's what I
Thank
thought.
you. Yes,
Okay.
great
All right, thank you.
observation. Thank you.
Okay, yeah, good question, Chairman. Members, any other questions? All right, thank you, Judge. The chair now calls Constable, correct?
Yes.
Constable Larry, is it Gallardo?
Gallardo, well,
Okay.
if you're south of San Antonio, it's Gallardo, and if it's
All
north
right.
San Antonio, it's Gallardo. So
Great.
However you want to pronounce it.
Got it. You're here on behalf of yourself and the Justices of the Peace and Constable Association for the bill. Is that correct?
That's correct.
All
Good
right,
afternoon.
And the chairman will show Representative Dyson as president as well. Go ahead.
Good afternoon, Chairman Leach and members of the committee. My name is Larry Gallardo. I am a constable from Hidalgo County, precinct number 3, and I've served over 24 years. And I'm here to testify in support of HB 2176. I represent the Justice of the Peace and Constable Association in Texas, which is a large association of the most elected officials with over 2,300 members. I am past president, and I'm currently the chairman of the legislative committee. I don't want to be repetitive of, as my colleague has shared with details on what courts experience, so I will keep my testimony short. Court security has been the main concern of the Justice of Peace courts and constables around the state of Texas for years. As a mandated constitutional bailiffs of the justice courts, it is critical that a representative of the constables in the county be included in the court security committee. It should also be said that the Justice of the Peace need a representative to serve on the committee as well. Having representation on the committee for the courts and their bailiffs is essential to addressing the needs and concerns of the courts and which are directly affected. As always, JPCA is here as a resource and to answer any questions or concerns. Thank you for allowing me to speak today and for your support and consideration for House Bill 2176.
Thank you, Constable. Members, any questions? Okay, Judge and Constable, thank you each for, were you finished with your testimony?
Sir?
Were you finished with your
I'm
testimony?
finished with my testimony.
Okay,
Thank
all
you.
right, I didn't want to interrupt you.
No.
Thanks to each of you for your service. I don't see any questions from the members on the dais, so thank you again. Does anyone
you.
else wish to testify on, for, or against? Y'all are excused.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 2176? Seeing none, the chair recognizes Chairman Harless to close on the bill.
Thank you, Mr. Chairman and members. It's just a cleanup bill,
Yeah.
simple, common sense bill, and if y'all want to go ahead and vote it out, right now, I'm
Well,
good with it.
I was actually going to ask you, Chairman, we're not going to do it right now, but we are holding a formal meeting tomorrow morning. Is the committee sub in its final form ready to
Yes,
be
it
voted
is.
on?
It's ready to go. Thank you so much.
Okay, we'll
and I
take this up
close.
during pending business tomorrow during our formal.
Thank you, Mr.
Thank you, Mr. Chair. Members, any questions for Chairman Harless? Seeing none, the chair withdraws the committee substitute to House Bill 2176 and leaves House Bill 2176 pending at this time. Ready? The chair now lays out House Bill 2884 by Chairman Landgraf, recognizes Chairman Landgraf to explain the bill. The chair lays out the committee substitute to House Bill 2884 and recognizes Chairman Landgraf.
Thank you, Mr. Chairman. With your permission, I'll just lay it out from the
Absolutely,
dais.
yes.
HB 2884 amends the CPRC to require a claimant who is receiving funding from an ITAR-sanctioned country to disclose that fact in civil actions involving defense contractors. The committee sub before you applies to actions involving defense contractors. The other change in the committee sub makes the definition of defense contractor more precise. Together, these changes make the bill more targeted and less susceptible to causing any unintended consequences, which of course we're trying to avoid. Mr. Chairman, I'm happy to answer any questions that you or the committee members may have.
Okay. Members, any questions for Chairman Landgraf? Let me see. Is he want to testify or not? Okay. Does anyone want to testify on, for, or against House Bill 2884? All right, seeing none, the chair will recognize Chairman Landgraf to close on the bill.
Thank you, Mr. Chairman. I close.
Members, any questions for Chairman Landgraf? Okay, the chair will withdraw the committee subs to House Bill 2884, and we'll leave House Bill 2884 pending at this time. The chair lays out House Bill 4145 and recognizes Representative Dyson to explain the bill.
Mr. Chairman, with your permission, may I lay it out from the
Absolutely.
dais?
Is this your first bill layout?
It is not my first.
Oh, okay, all right.
Old Pro.
Take it
Old-
away.
Old Pro. Thank you, Mr. Chairman, fellow members. Currently, Texas law requires a healthcare provider to submit a bill to a patient, their health insurer, or other responsible party within 11 months of providing healthcare service. Failure to comply with this requirement results in the provider forfeiting their right to payment. This requirement protects patients from unreasonably delayed medical bills. To be clear, my bill does not affect this notice period. This bill is designed to close a loophole, which I'll explain a little bit more. When someone gets hurt and obtains legal representation in a personal injury claim, a healthcare provider may provide treatment under a letter of protection from an attorney. Under a letter of protection, the provider agrees to treat the patient and delay receipt of payment until the personal injury dispute has been resolved in exchange for a promise to be compensated later. In such instances, the provider might submit a patient's bills to the patient's attorney rather than to the patient directly. But as letters of protection often say, the attorney is not responsible for the patient's bills, and some attorneys and insurers have begun to use the law's timely billing requirement to avoid paying the provider, arguing they failed to comply with the timing billing requirement and are therefore not entitled to payment. House Bill 4145 seeks to close this loophole by permitting a healthcare provider to satisfy the timely billing requirements by submitting a patient's bill to their legal representative in a personal injury claim within 11 months of providing the service unless otherwise directed by the patient. Thank you, Mr. Chairman, members, and with that, I'm happy to answer any questions the committee may have. Otherwise, I reserve my right to close.
All right, members, any questions for Representative Dyson on House Bill 4145? Okay, Chair calls Sean McCone. Is it Mr. McCone?
Yes.
Did I say your name
Yeah,
correct?
McCone, you
Okay.
got it right.
I've got you registered as Sean McCone here on behalf of the Texas Chiropractic Association and yourself, registered for the bill. Is that correct?
That is correct.
All right, go ahead.
Very good. Thank you, Mr. Chairman and members. My name is Dr. Sean McCone. I'm here to testify in support of House Bill 4145 on behalf of myself and Texas Chiropractic Association. I am a chiropractor here in Austin, Texas. Thank you for the opportunity to be here, and thank you, Representative Dyson, for your hard work on this issue. As he had mentioned, this issue was brought to our association's attention during the interim. The law requires the provider to send a bill to a patient or other responsible person within 11 months of providing a healthcare service or otherwise forfeit payment. TCA supports this provision as it helps ensure the patients get their bills in a timely fashion. This issue was brought to us, and however, we've been told that we have seen some complaints from enterprising attorneys who are using this requirement as a loophole to avoid paying treating providers in personal injury cases. In short, when someone gets injured in a personal injury claim, they may not have the means to pay for their treatment. In such cases, their attorney might ask their provider to treat the patient under a letter of protection, which says that that provider agrees to be paid for those services once the case is resolved. The provider might then submit the patient's bill to the attorney rather than to the patient. Since letters of protection often include language saying the attorney does not guarantee payment or is not responsible for the bills, after 11 months go by, the attorney argues that the provider failed to comply with the state's timely billing requirement and thus isn't entitled to payment, since they only sent the bills to the attorney and the attorney isn't the responsible per the letter of protection. This appears to us to be a loophole in a timely billing statute that, and it's not its intention. House Bill 4145 would prevent this loophole from being exploited by allowing a provider to satisfy the timely billing requirements by submitting the bill to a patient's legal representation in a personal injury case, unless, of course, the patient directs the provider to do otherwise. If you have any questions for me.
Chairman Dutton.
Thank you.
Yes.
The letter of protection guarantees payment, does it not, from the proceeds, whether it's trial or settle?
It protects, it's not a guarantee of payment, it protects them in the case that there is a settlement that comes out of that.
When you say it doesn't guarantee a payment, I'm not sure I quite understand. So, why would you accept a letter of protection that doesn't protect you?
Well, Sometimes in some, well, it's rare circumstances that it doesn't happen, but if the case falls through or doesn't settle, then there's no guarantee of payment for that through the attorney's office.
Yeah, well, okay, I'm a little confused then, because
Sure.
what the bill says is that we're gonna, we're gonna send the bill to the attorney, and that would
Correct.
satisfy the requirement to do it within 11 months, if that's done in 11 months, right?
Correct.
And you accept letters of protection for what reason?
For compensation through the case.
Well, I know, but that's the same thing you get from the patient. But the letter of protection is to serve what purpose, though?
To allow you to, it protects your billing in the case, saying that the attorney, should they obtain a settlement through the case, through that they will come back and pay for the services provided to their client.
Settlement or trial or whatever the case is
Correct.
disposed of.
Yes.
But, so wouldn't that fall under the provision in the current statute that says, or the patient's representative?
No, so sometimes the letter of protection says they're not the responsible party for that, and so
Says the
that's the
lawyer's not-
loophole that gets them out of it, and says you sent the bill to the attorney on the case and not to the client.
But the letter of protection does say they will guarantee payment to you if the case settles or if you go to trial or however it's disposed of, right?
So a lot of the letter protections are not a guarantee of payment.
And you
And-
accept those?
Yes,
Why do you accept it if it's not a guarantee of payment?
because
Why do
a
you
lot of
need it?
patients don't have the ability to pay for their healthcare services for that, and so you're providing that service to the patient at the risk that it may not be covered service.
But the letter of protection comes from the lawyer, not the patient.
Correct.
So why would you, I'm not quite sure I follow you.
Sure, so,
Yeah, that's what I'm saying. It makes them a responsible party if they gave you a letter of protection in the case.
a lot of the language of letters of protection is saying that they're gonna represent the client, and should an outcome come out where they can reimburse the bills, they will attempt to do that, but it's not a guarantee of payment, and the attorneys are not the responsible party on that.
And so you don't look to the attorney to pay you out of the proceeds if you accept that kind of letter of protection, do you?
You do.
You do expect the attorney to pay
You
you?
do, and if they don't, then it could be a responsibility of the patient.
Okay, I'm a little confused, but, okay.
Yeah, Representative Flores.
Okay, so the letter, what you're saying is this bill closes a loophole in case they're trying to game the system.
Right.
You know, so this would say that if you sent the letter to the attorney, it actually tolls that,
Tells
that
us-
loophole. It closes that loophole. However, to Harold's point, Representative Dutton's point, is this just because you're gonna hedge your bets that if, in case there's a settlement and the letter was sent to the attorney, and they had a letter of protection, that therefore then, that there will be payment once there's a settlement or they receive, or a
Yeah, so
judgment?
there's some enterprising attorneys who are using this loophole to not pay providers, saying you didn't provide the bills to the patient, you provide it to their attorney, and we're not the responsible party.
I get it. So if they settle,
Yeah.
then you're closing the loophole for that. But it does not mean that if there is no settlement or there is no judgment in favor of the plaintiff, their client, then that does not guarantee, they do not have to pay the bill, correct? Because it's not their responsibility to pay the bill.
That's, yes.
That's correct. I mean, because only if there's a settlement, then they can't use it to say, oh, you didn't do it timely, but
Sure.
But it does not mean that then if there is no judgment or there's no settlement, so no dollars earned, that the lawyer is then holding the tab for the services that were provided for the client, correct?
Correct.
Okay.
Yes, Representative LaHood.
Thank you, Chairman. Mr. McCone, correct me if I'm wrong. At the most simplest terms, what's going on now is because of how the law is written, under the notice requirement,
Yes.
providers aren't being paid for the services they performed when they should have.
That is correct.
And so what this doesn't change it, this isn't gonna make y'all, like, change the burden or all that. All this is saying is that that notice requirement, because it's going to the attorney, who is a representative of the client, all it is an extension of that. It's not,
Correct.
makes sense, thank you.
Yep, yes.
Representative Schofield.
Mr. McCone, let me try to understand where this is coming from.
Sure, go ahead.
The ordinary use of the statute, my understanding is, we require payment, we require a bill presentation within 11 months so that the patient can get his insurance to cover it and doesn't get stuck with the whole bill because he can't timely file his insurance in a normal situation where a person's going to their doctor.
Yes.
It seems to me the situations you're talking about is where the plaintiff lawyer sets up the visit from the doctor. So whether it's the chiropractor or an MD, the plaintiff's lawyer is organizing this and then gaming it by saying, well, you didn't give me the, but what I'm struggling with is why we need to get in the middle of it. It seems to me there's a fairly closed loop of people whose practice is predominantly through plaintiff's lawyers. And once you all know this is the issue, it would seem like if you just started filing your bills within 11 months, you wouldn't need us to fix it. So why do we need a law to tell those of you, those few of you who sort of deal predominantly through plaintiff's lawyers in your practice, why do we need to change the law when you all now know, well, this is an issue, I best present my bill within 11 months?
Yeah, it's more of a cleanup. We want to provide the bill to the responsible party. The patient hired their attorney, which is an extension of the responsible party. Once we provide that billing to the attorney, then that quantifies that. That's what we're trying to clean up, that's part of that. If they're represented in a personal injury case and they have an attorney, we provide that billing to that attorney. That qualifies them as the responsible party.
Is there any reason why you couldn't present your bill within 11 months?
No reason at all.
So why, and again, I'm not trying to be,
Sure.
but now that you all know that this is something you got to watch out for,
Sure.
right? Why don't you just start presenting your bills within 11 months? I mean, they're not going to change, are they? I mean, and I know I'm usually on
So
the defense
it's-
side, so I'm often wondering if
Yeah.
these bills are real. But assuming that they are, and the patient has come to see you for, I once had a case where there were literally 30 chiropractic visits in 1 month on what they wanted us to pay as fees. So I kind of, or as medical expenses.
Sure.
So I can be skeptical, but assuming that, and if you come here to testify to us today, I'm going to assume you're an up and up guy, or you wouldn't
Yeah.
want to be in the limelight. So you actually performed the service.
Yes.
You can say it was on this day at this time, and I did whatever I did. Why couldn't you just present that bill within the 11 months, even though you know, okay, the patient didn't come to see me off the internet or from a family friend, they came through an attorney. But regardless of which way they came to you, you know you got to get them a bill in 11 months. Why not just do it?
Sure, and so we do provide them a bill, and we send the bill to, if we're under letter protection, the assumption is that they're the responsible party for the billing and records. Everything goes to that representing attorney for that. And then we want that to qualify as us providing the bill to the responsible party and not just the patient.
I get, and maybe I'm just less comfortable than maybe the author is with the idea that the lawyer is really the client here instead of the patient. To me, you perform the service for the patient. Why not just bill the patient, irrespective of maybe one patient comes in at 2 o'clock who comes in through a lawyer because he's had a car wreck. The other one comes in at 3 o'clock who just needs a back adjustment. They're both patients of yours.
Yeah.
Why not just send the patient the bill rather than, even if predominantly, and it may be 80% of your practice comes through the trial lawyer, but still, why not bill the patient?
Yeah, so no problem billing the patient. We have no issues with that. That's the standard of practice currently that's being done on that. But there are cases where the billing was maybe just sent to the attorney because the perception when you get the LOP or you get the records request is that it goes to that attorney. The bill has gone out. And so the perception by doctors providing treatment in personal injury cases is that we have provided the patient the bill through their attorney's office, and that should quantify that.
But I think that's my question. Why not, the patient comes in, they fill out their paperwork, they live at 123 Main Street.
Yep.
Why not send them, even if you want to, as a portion of your practice, also send a copy to the lawyer so he knows what the bill's gonna be? Why not send a copy of the bill to the patient like you would with the next patient who isn't in a car wreck?
Yeah, no problem sending the patient the bill, but in the cases where we also send the patient the bills to the attorney as well too, that we want that also to be qualifying as providing the bills to the patient as well when we provide it to their legal
But you said
representation.
two. If you had sent the patient the bill, you wouldn't need this statute because you would have followed the law and billed the patient within 11 months. I'm just not sure why we would need to get in the middle between the trial lawyer and his client and the doctor. But that's, you've answered my question, and I do appreciate it.
Representative LaHood, and then Chairman Dunn.
Thank you, Chairman. And correct me if I'm wrong, I personally believe in efficiency. Currently, if you send to the patient and to the attorney, you're sending out 2 certified mails or whatever the requirements are, 2 packets, 2 printings. Basically, double work's going on, like, is I guess what Representative Schofield is suggesting. And so, my question to you, in your professional opinion, if this amendment is made, you can still send it to the patient. That's not precluding you from that. All it's saying is that if you instead decide to send it to the person's legal representative, which I'm pretty sure all parties, both for and against medical insurance, is aware that they are now the legal representative. All this is saying is, hey guys, instead of y'all having to ask the patient for paper, me for paper, and the lawyer for paper, you're saying it's all in one-stop shop. I mean, in my opinion, it seems to streamline it and make it more simple and actually better for everybody. You have one place to go to. Am I wrong on that? I mean, I might be dumb.
No, you're right. You are absolutely correct on that. Yeah.
Okay. Thank you.
Chairman Dunn.
This, and I'm getting back to what Representative Schofield said. This extends not only to patients who come to you by virtue of a lawyer having sent them, if the patient just came on their own to you, this would apply to them also, wouldn't it?
If they had legal representation, yes.
Well, if they came without legal representation first and
yeah.
got legal representation afterwards.
Yeah. So the statute already says that we will provide the patient with a bill within 11 months. We're not changing that. That's a good law. It's a good rule for that. What we're saying in the instance is that they also have legal representation, that when we send that bill also to the attorney, that also qualifies as sending it to the patient too, as that's the extension, their legal
Correct.
representation, extension of themselves.
Correct. But I think Representative Schofield was limiting it to where lawyers sent you the patient. And that's not the case, is it?
Is it limiting it to?
Yeah, to cases only where the lawyer sends you the client.
When they have legal representation and then they are wanting those records and bills to them, then yes, in that case, just in a legal representation in a personal injury case.
What do you do if the client comes and says, no, I don't have a lawyer?
Send him the bill.
You send the bill just like you always would. None of that changes.
That,
from
I
that. We
understand,
wanna
I
provide
understand,
the
I
patient
understand.
the
I
bill
got
within
that, I
11
got that.
months.
But I just want to be sure that,
Yes, sir.
that what Representative Schofield seemed to say was, this only applied to where
Not only,
plaintiff's lawyers sent you the client.
their concern is only in that case, not,
Yes.
it would apply to everybody.
Yeah, okay, well, okay, so the concern would be where the client comes to you, and if they had a lawyer, you have a obligation under any scenario to send them the bill within 11 months
Correct.
under the current statute.
Correct.
And of course, the other thing I was wondering is, and this does happen, where a client comes in and they go to you afterwards, but then they change lawyers. And so what do you do in that case?
Well, we're still always sending the patient to the bill, so we always meet that requirement. But in the case they have legal representation, we would send it to the attorney representing them.
Do they have to give notice to you if and when they change counsel?
It would be preferred to do, but if not, there's still the patient.
How would you know otherwise?
Yeah.
They would have to tell us. We might get a drop letter from the current representation that they're no longer being represented, and you'd reach out to the patient to find out if they have further representation or if they'll be taking care of the bill themselves. That's been supplied to them.
Well, that's why you ought to always send the bill to the patient,
Right.
Yeah,
irrespective of
we'll
what.
always send the bill to the patient, it's totally fine, but also sending the bill to the representing attorney as well.
So, hold on, I'm getting lost. So you do actually send the bill to the patient even though you send it to the lawyer?
Yes, but in cases where you get yes, all patients get the bill within 11 months, but in cases when you get a letter of protection, they're requesting the records, and so providers are providing those billing records to the attorney, the assumption is I've provided that to the patient through their legal representation for that.
Do you cease at that point sending it to the patient?
No, it's still being provided to the patient, but there's lots of instances when they are represented that they would only send it to the attorney and not to the patient.
City, Representative Schofield.
I understand that your practice may be to send it to the patient, but that's not what the bill's talking about. The bill is saying that the provider may satisfy the requirements for giving 11 months by submitting the bill to the patient's attorney. So that you could only send it to the patient's attorney and not the patient and satisfy this bill. That's what I'm saying.
But
Let me,
Mr. Chairman,
yeah, Chairman Dutton, you've still
if
got the
you,
floor.
if you're sending it to the patient now and the lawyer, then you don't have a problem.
Right. A lot of, yes, that would fix that as well too, but a lot of doctors are just sending it to the attorney and not to the patient.
Oh, so you're
Under the
not doing that.
representation that the attorney is representing the client, they are responsible for the bills. and
Can I,
supplying that.
Representative Flores, let me get to you in a sec. Chairman, keep your microphone on.
But
I'm sorry for jumping in, Chairman, but
That's
I
okay.
want to clarify where we are right now. In that situation where a doctor is not sending a bill to a patient, has the patient given them permission to send it to their attorney as their agent? Has the patient given permission not to send a bill to them and instead send to their attorney?
Yes. So in those cases, you're sending it through to the attorney.
Is that,
I think I got it.
Representative Flores? And the bill author is recognized as well to jump in at any point.
I just to clarify, I mean, for me, that when you do have this letter of protection, again, and whether it's sent to the client and the lawyer, as long I get tolling the notice requirement for the 11 months saying, yes, it did get there if you send it to the lawyer and inadvertently did not send it or even on purpose didn't send it to the patient as well, that would just say that they can't use that excuse
That's what
to not pay the bill. However, the letter of representation or whatever it's called, still, you're not changing anything about saying if there is no judgment that they are not now, that the lawyer is required to pay. That does not change, correct? Okay, that's where I'm
Yeah,
hooked up on.
Representative LaHood. You sure? Go for it.
Thank you, Chairman. Listen to all the great questions and talk. This, and from great insight, this reminds me of basically longstanding best practice principal agent theory that we've applied in law. That once you representing in that legal capacity, that you are now the representative. So that makes sense to me. as a lawyer, we have an ethical duty to notify our clients timely updates. And so I think this actually might make Mike happy. This actually shifts the burden now to the hated plaintiffs' lawyers to update their client.
Yeah.
Minus present
Strike
company.
that- strike that.
Minus present company. No, but all kidding aside, the other thing I'm thinking about is the notice requirement. The notice requirement of the underlying law is still being met because, one, efficiency. Two, the lawyer is still obligated to keep their client updated. I don't think it's hurting anybody other than just making it more efficient. So, thank you.
Members, any other questions for the witness? All right, thank you, Doctor. That was interesting. Thank you. Seriously. Does anyone else wish to testify on, for, or against House Bill 4145? Seeing none? I mean that sincerely, Doctor. Thank you for the testimony. Normally, members, we've had a non-lawyer on this committee to bring us back to earth, and we don't have that gift this session. So, so we're gonna, right. Well, that's true. And the chair will recognize Vice Chair Hayes is here. Does anyone else wish to testify on, for, or against House Bill 4145? Seeing none, the chair recognizes Representative Dyson to close on the bill.
Thank you, Mr. Chairman. It was spirited testimony, a lot of great questions today. I do think this hits on efficiency. It also hits on principal agent idea. And yes, it does seem to be a certain sector that it applies to, but I think it's an important issue for us to say what the original notice intent was of this law, and that's all we're trying to uphold here in this specific situation. With that, I'm happy to answer any specific questions the committee may have. Otherwise, I close.
All right, members, any questions for the bill author? Okay, the chair will leave House Bill, 4145 pending at this time. Okay, members, the chair lays out House Bill 3223 by Chairman Leach. Members, I appreciate you allowing me the opportunity to lay this bill out today. In recent sessions, the legislature has reviewed and lowered the statute of repose on various construction projects. In 2021, we shortened the statute of repose on public commercial projects from 10 years with a 2-year tail to 8 years and with a 1-year tail. Last session, we addressed private residential projects, reducing the statute from 10 years down to 6 years if the builder provides sufficient warranties. However, on private commercial projects, the statute of repose is 10 years. And while Texas is tied for the second longest statute of repose, 26 other states have a limit under 10 years, and 16 of those are actually 6 years or less. House Bill 3223 in front of you today, members, seeks to bring private commercial projects in line with public commercial projects by reducing the statute of repose to 8 years with a 1-year tail. This better aligns statutes of repose across projects of different types, and it puts Texas in a better position, more competitive position nationwide in this regard. Members, I'm happy to answer any questions and reserve my right to close. Seeing no questions, there are 2 witnesses who registered to testify for the bill. The chair recognizes, I've got Corbin Van Arsdale here on behalf of the AGC Texas Building Branch for the bill. Is that correct?
Yes, sir.
All right, go ahead.
Corbin Van Arsdale, President AGC for the bill. The layout's good. I wanted to compliment your staff and your committee staff. You have a very well-run operation.
I agree.
And so thank y'all for how you've been. I got nothing else to add. You saw a handout that kind of really explains very vividly. The left column is how the current law is set up. The right column is how the law would be if this bill passes. It just makes the public and private construction projects with the same statute of repose. Right now, it's different.
Okay. Members, any questions for Mr. Van Arsdale? Okay. Seeing none.
Move passage.
All right, the chair recognizes William Westcott. I have you here on behalf of ABC of Texas and yourself testifying for the bill. Is that correct?
Yes, thank you, Chairman Leach.
You want to be
Williams-
listed as William Westcott?
Yeah, William is the name my parents gave me, so
Okay.
that's where that comes from.
All right, I actually never knew that, so glad you're here. If you'll, so you're for the bill?
Yes,
All
thank
right,
you.
go ahead.
Ben Westcott, 25-year board-certified construction lawyer for the bill. I would just like to add that bringing this in line for public and private projects helps contractors standardize procedures for document retention, helps them monitor existing liabilities. It really creates some conformity for those contractors that operate both in the private and the public sphere. It also helps them in terms of subcontract agreements, contract documents, and things that would set insurance requirements and other things such as completed operations insurance, and it gives them fixed timelines for that. Otherwise, you have confusion. Sometimes you need insurance for 10 years, sometimes you need insurance for 8 years. And so for those reasons, we're in favor of the bill.
Okay, thank you, Mr. Westcott. Members, yes, Representative LaHood.
Thank you, Chairman. So currently, commercial projects is an 8-year retention or repose.
10.
What is the?
We're looking to move private commercial from 10 to 8.
Which one is 8 already?
The public.
Okay, so public, so that's what I missed. One of them is already 8.
Yeah, public.
We're just saying, make it all consistent,
Make
make
it all
it
the
more
same.
efficient, make it just streamlined.
Yes, sir.
We changed that in 2021. and
Yeah.
This will bring us into line with that.
That makes sense. Thank you.
All right. Members, any other questions for Mr. Westcott? All right, thank you both for being here. Does anyone else wish to testify on, for, or against House Bill 3223? Mr. Baxley, no? All right, all right. Seeing none, the chair will close on House Bill 3223. Members, if you have any questions for me, I'll take them. Seeing none, the chair will leave House Bill 3223 pending. The chair now lays out House Bill 933 by Chairman Spiller and recognizes Chairman Spiller to explain the bill.
Thank you, Mr. Chairman. Chairman Leach, members, thank you for allowing me to lay out House Bill 933. Due to Texas dual high courts, the Supreme Court of Texas and the Texas Court of Criminal Appeals, there are instances when the same legal provision, either statutory or constitutional, has been given 2 different meanings, both of which are binding on the state. This happened most recently in the State versus Stevens case, a 2021 Texas Court of Criminal Appeals case, which addressed the issue of the legislature's ability to, or inability, to empower the Attorney General of Texas to represent the state and prosecute election law offenses. This overlap of authority and inherent conflict has gone on for years. Even back in 1910, in State versus Schwartz, the Supreme Court addressed the problem of the independent jurisdiction of the 2 courts of last resort and the conflict. As a result, there can sometimes be confusion about which court should address a particular question or issue about which there could otherwise be a conflict. This creates confusion for the legislature, for elected and executive officials, and for individual Texans. House Bill 933 is written to create a limited mechanism to address constitutional questions upon which the Supreme Court of Texas and the Texas Court of Criminal Appeals may disagree. House Bill 933 permits the Supreme Court of Texas, in the exercise of appellate jurisdiction, to consider a specific question of constitutional interpretation upon which it may disagree with the Texas Court of Criminal Appeals by means of a petition for writ of certiorari. This process should fall within the Supreme Court's constitutional jurisdiction under Article 5, Section 3 of the Texas Constitution, and as allowed by Article 5, Section 5 of the Texas Constitution relating to the jurisdiction of the Court of Criminal Appeals. A writ of certiorari is appellate in nature and calls for the judicial review of another court's ruling. It is neither inherently civil or criminal in nature. The grant of such a writ to a particular legal question doesn't appear to give the Supreme Court jurisdiction that it doesn't already have under the Texas Constitution. Simply put, this bill allows the Supreme Court of Texas to give a uniform interpretation of a constitutional provision, avoiding a potential for a conflict. With that, Mr. Chairman, subject to any questions you may have and the committee may have of me, I thank you for your time. Respectfully reserve the right to close.
Okay, thank you, Chairman Spiller. Representative Flores.
Have the courts weighed in on this?
All
I
right.
mean, what do they say? I mean, don't they interpret the Constitution all the time? So why isn't it resolved if it's in the Constitution as you?
Well, I think potentially, historically, there have been a problem if the Court of Criminal Appeals issues a ruling on something in a criminal case, but affects a constitutional provision that may also affect something that's civil in nature. And so this would give a very limited ability for the, and I can go back and talk about a 1910 case if you want. It's a pretty interesting case. It's out of Cook County. One of my counties has to do with intoxicating beverages. But the effect of the case was that it took away, it basically nullified an election, which would be otherwise governed under a civil proceeding. And so the Supreme Court didn't have the opportunity to weigh in. Here, the same type of thing happened in the recently in the 2021 case, where if this had been in effect, then one of the parties could petition to the Supreme Court. The Supreme Court could ask to hear that on that constitutional issue. So that wasn't afforded. So this is not a review of that case. That horse is already out of the barn. But this is for future disputes to resolve any potential conflict that there would be.
Representative Schofield.
Mr. Spiller, are we one of only 2 states that has 2 top courts? Us in Oklahoma, right?
I've heard that. I haven't independently researched that.
But in the other states that don't have a provision like this, it's because they have one Supreme Court is the final arbiter of what their Constitution means, whereas we have 2. You could have a case that goes up to the Court of Criminal Appeals, and they decide a provision of the Texas Constitution, and a different case goes up to the Supreme Court, and they decide what that same provision means, and they could decide 2 different things. When the 1st and the 14th Courts of Appeals have that, we have a Supreme Court to deal with it. When the Court of Criminal Appeals and the Supreme Court disagree, we got nowhere to go. And so your bill would say the Supreme Court is the arbiter of the whole Constitution, and they will make the decision on what
They have the
constitutional provision means.
opportunity to. Now, whether they choose to do so or not, but they
we
certainly,
leave that
under
to
this,
their
they would have
discretion.
the ability to do that, yes.
Thank you.
Members, any other questions for the bill's author? All right. Seeing none, we've got a handful of witnesses here who've registered positions on the bill and want to testify. The chair calls, we'll do this in 2 panels. The chair calls Alan Place, Jack Rhodey, and Philip McFurlow. And then then the next panel will be Jennifer Lundy, Brandon Johnson. And is there a Chapman? Okay. Alan, let's start with you. I've got you here on behalf of the Texas Criminal Defense Lawyers Association registered against the bill. Is that correct?
That's correct, sir.
All right, go ahead.
Thank you, Mr. Chairman, members. My name is Alan Place. On behalf of the Texas Criminal Defense Association, we respectfully oppose the bill in front of this body. Just a couple of short facts. One, the creation of the Court of Criminal Appeals is found in Article 5, Section 5 of the Texas Constitution. Similarly, the Texas Supreme Court is created in Article 5, Section 3 of the Texas Constitution. The jurisdiction of the Court of Criminal Appeals basically says this in the Constitution, that Court of Criminal Appeals has the final say in all criminal cases, period. In regards to the Supreme Court, the language basically is that the Supreme Court of Texas has the final say in all cases except for criminal cases. In fact, the Constitution repeats itself twice and basically says that it has, the final say except in criminal cases. So basically, it's been pointed out, the system that we have is a bifurcated system, an equal but separate authority. And this scheme has been upheld in numerous court cases recently. I think the last time was 2011. Our suggestion to the body is that if the court, if this body wants to change the court system, basically, it's going to have to be done through a constitutional amendment. What we believe is vested in the Texas Constitution must be amended in the same manner. And just a quick thought, in terms of the efficiency of the 2 systems, we think it works. This is a very old law, obviously being in the Constitution, but even when Texas was small, it worked well. When you have specialty courts, probate courts, civil courts, you have a court that answers or has the final say in those cases. And similarly, in your bigger counties, you obviously have specialized criminal courts, and to have a specialized criminal court to handle all criminal cases, we think works well a long time ago, and we think it works well now. That's all we have.
Thank you, Mr. Place. Members, questions? Okay, thank you for your testimony. The chair calls Jack Brody. Jack, I've got you here on behalf of Galveston County Criminal District Attorney.
Yes, sir.
Yeah, there you are. Good to see you, sir. Welcome back to the committee. I've got you registered to testify as the Galveston County Criminal District Attorney against the bill.
Yes, sir,
All
that's
right, go
correct.
ahead.
Mr. Chairman and members, thank y'all for the opportunity. Respectfully, Jack Rody, Galveston County District Attorney, I am here to speak against the bill because the bill is both unconstitutional and unnecessary. The bill is unconstitutional because it would effectively subjugate the Texas Court of Criminal Appeals to the Texas Supreme Court, and in doing so would violate the very framework that has existed in our Texas Constitution for almost 150 years. Article 5, Sections 3 and 5 set up these respective courts, and they have been created as coordinate courts. They are co-equal, and they are parallel courts, yes, but they're independent courts. The Constitution specifically sets forth the jurisdiction and domain of both the Court of Criminal Appeals and the Texas Supreme Court, and this bill would effectively, unfortunately, dismantle that framework that has existed for almost 150 years. The bill is also unnecessary because the Texas Constitution is not ambiguous on these matters. The Constitution both prescribes and proscribes jurisdiction and authority. The Constitution says that the court shall have jurisdiction in these areas, and it says the court shall not have jurisdiction in these areas, and it prevents these two courts from trespassing upon the jurisdiction of one another. And these two courts have done so effectively without any problems through at least 100 years of published opinions. The Court of Criminal Appeals and the Texas Supreme Court have successfully navigated this framework. When they recognize that an issue belongs in the jurisdiction of another court, they have stepped back from that and recognized that the Constitution delineates those clearly. I agree with my colleague that if there is a desire to change this, then the way to do it would be to amend the Constitution, that it cannot be done by statute. And so because the bill would be both unconstitutional and unnecessary, I respectfully ask that you vote against it. Thank you.
Thank you, Mr. Rody. Members, questions? Yes, Representative LaHood.
I guess my question is this, is currently, and I can't think of an example, but if there is an issue where the Court of Criminal Appeals and the Texas Supreme Court have jurisdiction on a matter, does the Constitution define what happens when we have competing interests? Kind of like we had our case a couple weeks ago where it was like two parties had equal rights to a claim. How do you decide which one has the superior claim? And so I guess my question would be, does the Constitution currently address what happens when we have a competing interest between our two highest courts?
Representative LaHood, you're well stated when you said you can't think of a situation where that would happen, because I can't either, and I don't know of any. These issues of interpreting our Constitution always arise and percolate up to the Court of Criminal Appeals or the Texas Supreme Court in the context of a criminal matter or a civil matter. And so when those rulings have been made, they have always been within either context. And I don't know of another situation or a situation where the courts have butted heads on the interpretation of the Constitution so that there had to be some arbiter between them. It hasn't happened yet that I know of.
And so my next follow-up question is this. Just because we can't think of an example or we haven't experienced one yet doesn't mean that, God forbid, not that we're not smart, but, it won't come up. And so my next question would be, if that issue arose, would this be a way of addressing it? Would this violate the Constitution, considering the Constitution doesn't address it, so you're not usurping power from one or the other? Is my next question.
Yes, sir. And respectfully, it actually would violate the Constitution because it would be granting to the Texas Supreme Court the right to overrule an opinion by the Court of Criminal Appeals on interpreting a constitutional matter. And because our Constitution very clearly establishes these as coordinate, co-equal courts, without a change to the Constitution, any attempt to modify that by statute would be fundamentally unconstitutional.
Representative Schofield.
Mr. Rode,
The
thank
chair
you.
will show Vice Chair Johnson is present.
Mr. First of all, thank you for coming today. I always enjoy going down to Galveston, and I'm glad when you come up to see us.
Thank you, sir.
I read Article 5, Section 5 differently from you. It says the Court of Criminal Appeals shall have the final appellate jurisdiction coextensive with the limits of the state, and its determination shall be final in all criminal cases of whatever grade. It doesn't give it the final arbitration on what the Constitution means. And it doesn't sort of have a Marbury versus Madison provision in there saying that they get to interpret the Constitution. They get to rule on the criminal cases. But, for example, if we had a bill that said, okay, you're going to make the final determination on a criminal case, but if you come to a constitutional interpretation of what a provision means, you have to go and certify the question to the Supreme Court. They would still get to make the final decision in the criminal case, but it wouldn't run afoul of this provision. It doesn't specifically give them the right to be the arbiter of the Constitution. I don't see in the Constitution where it says that. Can you enlighten me?
Yes, sir, and respectfully, I would disagree on that, because if the Texas Supreme Court then has a right to subjugate the Court of Criminal Appeals' interpretation of the Constitution to its own ruling, then it, in effect, becomes the final arbiter in that criminal case. Because if the Court of Criminal Appeals makes a constitutional ruling in the context of that criminal case, and that question somehow gets certified to the Texas Supreme Court, and the Texas Supreme Court disagrees with the Court of Criminal Appeals' constitutional interpretation, it will necessarily overturn the opinion of the Court of
That's not how
Criminal Appeals.
certifying the question works. You don't make a ruling and then certify it to them. When you reach a point where you have to determine what the and this happens every day in the not every day, but it happens on a regular basis in the federal courts. The Fifth Circuit will certify the question to the Texas Supreme Court. They don't rule on it and then say to the Texas Supreme Court, how do you think about this? They say, well, this is your jurisdiction. You tell us what the Texas Constitution means. You send it back to them, and then they continue on in ruling with their case. Now, that's not the way Mr. Spiller's bill is written, but to your constitutional point, there's nothing in here that says that the Court of Criminal Appeals gets to say what the Constitution means. It just says they get to be the final ruler on criminal cases. If we get to a point where they have to determine what the Constitution means, and they were to have to go send that over to the people who do that for a living, they would still get to make the final ruling. Now, that's not quite the way the bill's written, but the point is still the same. They're not subjugated to the Supreme Court. We are deciding, Supreme Court gets civil cases, Court of Criminal Appeals gets criminal cases, but who decides what the words of the Constitution means? And under Mr. Spiller's bill, it would be the Supreme Court that would decide that. I don't see that interfering with Article 5, Section 5.
Well, sir, again, respectfully, I would disagree with that, because the Court of Criminal Appeals, in doing the work that they do, interpret the Texas Constitution all the time. It's what they do. And so anytime they have to make an opinion about whether the state's conduct or anything else that happened in the underlying case, whether it was done correctly or whether the case should be reversed, the tools of their trade are the elements of the Texas Constitution. And so they would never be able to be the final court for a criminal matter, because everything would then be going to the Texas Supreme Court.
Well, only the constitutional rules. Not everything they do is a constitutional ruling.
Fair enough.
Well, thank you. I appreciate it.
Yes, sir.
And maybe we'll have lunch and go over and figure out how we can work
Yes,
this out.
I know a good place.
Thank you, members. Yes, Representative, or Vice Chair Hayes.
I just want to make a comment. I know two of these fine gentlemen here. Jack, thank you for mentoring my son for many years.
Thank you for letting him work for me. He is an outstanding lawyer and prosecutor.
Well, I'm not going to take any credit for that. I'm going to give it to you.
Thank
That's
you,
what a
sir.
good job you did. And then my good friend here, Philip McFurlow. So good to see you again, sir.
Thank you all. Mr. Furlow? And I have you as Philip Mack Furlow, here for yourself and the 106th Judicial District, and you are against the bill.
Yes, thank
Thank
you,
you.
Vice Chair. My name is Philip McFurlow. I'm the District Attorney for the 106th Judicial District, which covers 4 counties in rural West Texas. And while I am a fan of Representative Spiller, I am against House Bill 933. The Court of Criminal Appeals was created in 1892 partially to take the pressure off of the Supreme Court of having to handle criminal law matters and civil matters. We haven't gotten any smaller. I have numerous practical concerns as it relates to post-conviction writs filed by defendants in both death penalty cases and non-death penalties. Let's say, for example, the Court of Criminal Appeals green lights an execution stating that all appeals in extraordinary matters have been exhausted. However, the defendant is seeking the interpretation of a constitutional issue in the underlying case and goes to the Supreme Court seeking relief. The Supreme Court would have to issue a stay. They don't have any history of the case. They haven't dealt with the facts of the case. And it would take them a significant amount of time to become familiar with the case because of their lack of prior involvement. They'd be hard-pressed to grant or deny based upon their lack of knowledge or the case facts, procedures, and applicable law. This is a very specialized area of the law in which the Supreme Court has no experience. Oftentimes, those claims are built around the Constitution and the violation of the Constitution. So this bill could be a lifeline in those death penalty cases. In addition to that, the bill could be used in any situation in which the CCA proceedings, where someone wants a second look at something that's not discretionary, or used in proceedings that have concluded. The Court of Criminal Appeals presiding Judge Shank sat in front of y'all a couple of weeks ago and talked about the overwhelming number of writs in their court, over 9,000. And with this bill, there is an opening to push to the Supreme Court those issues after the CC is ruled under the guise that it is a constitutional issue. So again, we think that this would be a heavy burden and a heavy cost on the system.
Thank you. Representative Schofield.
Now, Mr. Furlow, I spent most of my life on the civil side.
Yes.
My main experience with death penalty cases was working for the governor 20 years ago.
Sure.
So I'm going to ask you this from my memory, but you're referring to death penalty cases relying on the Constitution. It seemed to my memory almost all of those were the federal Constitution, not the Texas Constitution.
Yes, but again, those are interpretation matters, and sometimes those issues are taken before the CCA on a regular basis. If you look at their caseload.
Right, but this bill only deals with interpretation of the Texas Constitution. The U.S. constitutional cases would not leave the CCA to go over to the Supreme Court. So they wouldn't be affected by the bill.
I believe there is an opening for that to occur under the way the bill is drafted. And again, if you make the Supreme Court as the court of last resort, just by making a constitutional claim, those folks that are sitting in prison trying to figure out a way out usually will structure it and do everything they can. Now, granted, under the bill, the way it's written, the Supreme Court can deny cert. It doesn't mean that those won't get filed and be a burden on the Supreme Court.
Again, maybe I'm asking my question wrong, but it seems to me that, and if there's some ambiguity in the bill that I don't see between the U.S. Constitution and the state Constitution, I'm sure Mr. Spiller would be amenable to cleaning that up. But the bill would only say if we're going to have a difference of opinion, because there is a final arbiter for the U.S. Constitution. They're in Washington. Those 9 folks always can decide that. This is a bill about who'd be the final arbiter of what the Texas Constitution means
correct.
here. And I don't recall a lot of death penalty cases hinging on an interpretation of the Texas Constitution. And you've dealt with them. Do you know?
So all I can tell you is that the last one I was on was the Clinton Young case, and it was ultimately granted, but it was primarily local issues that dealt with a denial of a right to. It was a conflict of interest within the district attorney's office in Midland County.
Well, thank you very much, and thank you for coming. Appreciate it.
Members, any other questions for this panel? Representative LaHood.
Thank you. I'm still trying to get my head wrapped around it. I listened to Representative Schofield, and I start leaning that way. I listen to y'all, and I start going this way. I just want to be clear. Y'all's objection is that our current state constitution doesn't define what happens if there's a conflict between, I guess, priority or jurisdiction on something that involves both the Court of Criminal Appeals and the Supreme Court, right? I don't want to speak for y'all, but that's basically your argument or your objection to it.
Yes, so if it's a criminal case, it goes to the Court of Criminal Appeals.
Yeah, we all agree on
Period.
that. We all agree on
Period.
that. And if it's a
If
civil case, it goes
to the
there.
Supreme Court. So the
And-
Stevens opinion was a criminal case,
No, I get that.
and it went to the Court of Criminal Appeals, and that's where it stayed. There's no companion civil case before the Supreme Court.
No, I get that. And so I think the disagreement is, and we're all trying to think of a hypothetical, but hypothetically, if an issue comes up that falls in the purview of both, currently the Texas Constitution doesn't address that. Like,
We believe that it does currently address it, because if it originates out of a criminal case, it goes to the CCA.
well, sorry to be, I don't want to be disrespectful, but the Constitution doesn't say it originates, it just says a matter. I don't want to misquote it, I'm going to read it again, just so I'm not going to eat my own words.
It's a criminal law matter.
Yeah. But criminal law matters can originate out of a civil case, right? You can have a divorce that then becomes protective order, then becomes violation. I mean,
A protective order is a civil proceeding.
I know that. And a violation thereof could be criminal. What I'm saying is that just because it originates there doesn't mean that it can't jump over. I mean, it's the matter of what we're dealing with at hand, not that where it starts from. Like a criminal case could have some collateral effects that become a civil case as well, right? Like you can file a civil lawsuit for murdering somebody as well as prosecuting for murder.
Yeah, but again, that's a companion case. The civil case is the civil case, criminal case is the criminal case.
Yeah. But what I'm saying though is that it can change from that. And so what I want to figure out is this. So if the Constitution doesn't fix it, if this was a constitutional amendment, you wouldn't have an objection anymore.
No, then it would be up to the people to decide.
Okay. So and again, I don't want to put words in your mouth, just so I'm clear, because I'm trying to figure this out. This is actually pretty interesting. But
it's almost like a
law school.
a law
law
review
school
article or something.
hypothetical. Okay, but if the Constitution addressed it, y'all's issue is the Constitution doesn't address it. Y'all interpret it the way that y'all are saying. Okay, thank you very much. I appreciate it.
And if you do want to have the Supreme Court as the master Supreme Court, then we need to dedicate a bunch of resources over there for them to be able to handle the stuff that's going to filter its way over.
One last question. When I read Section 5 on Court of Criminal Appeals, it says February 15th, 1876. Is that when, like, originally did we not have a Court of Criminal Appeals? Were they created in 1876?
1892.
So there was a predecessor Court of Appeals to the Court of Criminal Appeals, but that court of, forgive me, Jack Rhodey, Galveston County DA, I didn't mean to jump in, I'm sorry.
No.
So there was a predecessor court in name, but the jurisdiction was the same.
Okay. Thank you.
Representative Schofield.
Mr. Furlow, let me ask you a question about something that you just said. And so he asked you, were you concerned that there could be two different rulings on two different provisions, and you weren't concerned about that? So what happens if we have, and I'll just take something that we're all familiar with, Article 3, Section 39 of the Constitution is just when our laws take effect. So if there, and a case could hinge on that. You could say, when I did it, it wasn't a violation of the law, or if in a civil case, when I did it, there was no remedy for this. And so we have the same words. We don't have two separate words, one Article 3, Section 39 for the Court of Criminal Appeals and one Article 3, Section 39 for the Supreme Court. What if cases go up to them and one of them rules one way and another rules another way? Do we have two distinct meanings for the exact same section of the Constitution because we have two courts that have ruled differently about what they mean?
And again, that to me seems a little far-fetched. I just know that
Doesn't seem very far-fetched to me.
Yeah.
Again, we see it with the First and the 14th Courts of Appeal all the time in Houston.
So whenever there's a new penal law adopted, which would, if we're going to indict a case, it's going to be under the penal code. There's going to be an effective date in that statute that says when it started. When that law takes effect. End of story. I don't see how there's any way to misinterpret when the law takes effect.
Oh, you'd be surprised.
So now there may be stuff on the civil side, but I know that when we deal with it on criminal cases, it is when the criminal act occurs, what the law was at the time the criminal act occurred.
Right, but
Period.
we're talking about when it becomes effective and when the law goes into effect. So let's say the Court of Criminal Appeals says, it's 60 days from the end of session, it's therefore it's this, we don't read what they put in the bill to create an earlier time, and then that's their ruling. And the Supreme Court takes the same thing and says, no, the way we read this, it's a 60th day unless by a 4/5 or 2/3 vote, both houses say it can be earlier, and maybe the final vote compared to the vote on the conference committee report, whatever it is, they have two different ideas of it. Without Mr. Spiller's bill, what we would have is the same exact words would mean one thing at the Court of Criminal Appeals and another thing for the purposes of the Supreme Court, and there would be no way to rectify the difference between them. So how would you resolve that without passing a bill like this?
And again, I'm only dealing with the penal code, and we're just gonna look to the penal code and abide by what the Court of Criminal Appeals says. And, you know, if they
That
wanna
doesn't answer
move
my
to
question.
the-
That's how one side would do it. We now have the same words giving two different meanings by our highest court,
Yeah, then
and
pass
there's
the
no
constitution-
tiebreaker.
Then pass the constitutional amendment to get it done. I don't see how you get around what is already in the Constitution.
And we're both, I'm sure all three of us fine lawyers. You may be better lawyers than I am, but I don't see where the ability for them to be the highest court on criminal cases means that they are the final arbiter of the Constitution, or a co-final arbiter, which could lead to the absurdity where we have the exact same provision of the Texas Constitution, the exact same words on the page being given two potentially diametrically opposed final dispositions on what they mean. But it's a very fascinating question, and thank you for coming all this way to talk with us about it.
Madam Chair, I'm sorry.
Hold on, Representative Flores, you have a question?
That's assuming that the Court of Criminal Appeals doesn't know how to interpret an effective date on a bill. I think they have fine lawyers. I mean, it's a bad example because they have lawyers that understand how to read a bill and how to read the effective dates. And so that's implying that the Court of Criminal Appeals would not come down, that they compete on that. So I don't think that.
Thank you. Members, any other questions for this panel? Thank you all. And the beard looks great.
Thank you, man.
It's good to see you.
Which one?
Chair calls Jennifer Lundy, Brandon Johnson, and Chapman. Jennifer Lundy, Brandon Johnson, and then Chapman. And Chapman is the only name we have down, so if that is you as the individual that attempted to register for this bill, we need to help you fill out the information completely. So if there's anybody that tried to register on this bill by the name of Chapman, please come down. All right. Jennifer Lundy, I show you as with Texans for Judicial Accountability, and you are against the bill. Is that correct?
Yes, ma'am.
You may proceed. Thank you.
Thank you, members of the committee. Thank you for the opportunity to speak today. Jennifer Lundy, Executive Director of Texans for Judicial Accountability, and I'm against HB 933. 933 is essentially placing the Supreme Court over the Court of Criminal Appeals. The Constitution establishes the jurisdiction of both courts and makes the Court of Criminal Appeals the final authority for criminal matters and the Supreme Court the final authority for civil matters. The addition that would need to be made on this bill by constitutional amendment, if it continues, is if there is an issue with a ruling from the Texas Supreme Court or an issue with a ruling from the Texas Court of Criminal Appeals, you can call for them to sit in bank together, all 18 of them. If it's still tied 9-9, they could add a long-serving intermediate appellate justice to break the tie. It is in the Constitution that of these two courts, one court is not higher than the other, and you cannot remove or add statute making the case. Therefore, we are against the bill unless amended.
Thank you. Mr. Johnson, I have you as Brandon Johnson here for yourself, and you are against the bill.
That's correct.
Go ahead.
All right, thank you.
Thank you.
I'm coming just as a layperson. I'm not an attorney, so from growing up, I learned that the the legislature, the judiciary, the executive branch is supposed to have a check and balance on the other branches. And what I have found since becoming involved with paying attention to government is that's not the way government is working. It's working in concert together instead of keeping each other from garnering too much power in one branch. And that's exactly what's happening right now in the judiciary. And both Justice Blacklock and Justice Shank have been open about recognizing that there's problems in the judiciary. And what I believe is happening, just from observation, is that you have a Abbott-appointed Supreme Court, and then you have a Court of Appeals who are elected, and they are fighting amongst one another. And what I believe is happening is the Supreme Court of Texas has petitioned the legislature to try to usurp the power, as Representative LaHood alluded to, and take that power and minimize what was otherwise two, equal branches of, or equal courts, high courts, and give that power to the, to the Supreme Court of Texas. And that's where I think I've seen over and over with the SCJC, with this issue here, with other bills, the legislature is absconding their power and handing it off to the Supreme Court, and they claim they're going to do something, but they have yet to do it. Thank you.
Thank you. Members, any questions for this panel? Thank you both so much for your testimony and your time. Again, anybody named Chapman who has registered for themselves and against the bill? Are you Chapman? Yes, ma'am. Great. We need a little help. May we help you fix your registration? Would you please give us your full name?
Charles Bryce Chapman.
Okay.
Bryce, B-R-I-C-E.
Great. We have your permission to correct the record?
Yes, ma'am.
Great. We have you as Charles Bryce Chapman for yourself, and you are against the bill, correct?
Correct.
You can proceed.
Oh, I didn't have any,
Got nothing to say other than that. All right. Well, thank you so much. Okay. Is there anybody else that wishes to testify on, for, or against House Bill 933? If not, the chair recognizes Chairman Spiller to close on his bill.
Thank you, Madam Chair. Let me address a couple of these, really 2 points, a couple of these concerns and things I've heard. And let me just say this, I've known Ms. Lundy, and she does a great job in advocacy. And the first panel, despite Philip McFurlow may be the most efficient prosecutor in the state of Texas, I'll give him props for that. He does a fantastic job. We respectfully disagree, but he brings up, there are 2 points, and I want to talk about his point first that he raised, to the extent we deal with death penalty cases and those type of things. I don't read it that way in the bill, and it talks about only things under the Texas Constitution, to the point he raised that if and to the extent that criminal defendants in a death penalty case or otherwise could that they could exercise something under this bill. Number one, there are reasons that they don't do that. There are reasons that they haven't potentially done that. But I'm certainly willing to work with any stakeholders to address that concern, if it is in fact a legitimate concern. I'm happy to work with anyone to try to address that, because that's not the purpose of this bill. To the other gentleman in the first panel, I have the utmost respect for them and what they do. I respectfully disagree with their contention, and to say that the Constitution says that the court shall not, that's not what the Constitution says. Words mean things. Our Texas Constitution means things. And if you actually read the words of the Texas Constitution, and I won't recite everything for the Supreme Court, they have the authority to do under Article 5, Section 3 to do what I've represented, but also under Article 5, Section 5, when you look at what the jurisdiction of the Court of Criminal Appeals is, it talks about that their decision be final in all criminal cases of whatever grade, with such exceptions and under such regulations as may be provided in this Constitution or as prescribed by law. The last time I checked, the folks around here prescribe law. We vote on those things. We have the ability to make this change in the law. And when we do, it is not in conflict with the Constitution because that exception is set forth in that. So this is not one court over the other. This is not a power grab. It's not that at all. It's to resolve in the rare instances, and hopefully they are rare and would continue to be rare, but in the rare instances where there is a constitutional question and the Supreme Court, someone needs to be the arbiter of that question rather than have competing rulings. And so I would just say that in closing, I respect their opinion, but in my view, it is not unconstitutional for those reasons. And I would, subject to any additional questions that you may have had of me, y'all have put up with a lot of difficult issues, especially in this committee. Is it like this every day? I don't know, but I appreciate the work that you've done, and I would just request favorable consideration.
Thank you, Chairman Spiller. Any other questions for Chairman Spiller? If there's no objection, House Bill 933 will be left pending. Hearing no objection, House Bill 933 is left pending. The chair lays out House Bill 2086 and recognizes Vice Chair Plessa to explain her bill.
Thank you, Madam Chair and members of this committee for the opportunity to lay out House Bill 2086 before you today. House Bill 2086 strengthens protections against frivolous lawsuits by authorizing the court to conduct a hearing determining if a plaintiff is a vexatious litigant without first needing a motion from the defendant. Vexatious litigation has been a persistent problem for decades. In 1993, a single plaintiff filed 40 lawsuits against the court pro se, despite previous rulings dismissing those same claims. As a result, the Texas legislature enacted Chapter 11 in 1997 of the Texas Civil Practice and Remedies Code to address the growing issue of vexatious litigants. Often, a defendant is unaware the plaintiff is a vexatious litigant and is overly burdened by the time and legal cost of a meritless petition. Without proactive judicial review process, such litigants can continue abusing the system at the taxpayer's expense. This bill ensures our civil courts, funded by the taxpayers, can effectively identify abusive litigation, reduce unnecessary legal costs, and maintain judicial efficiency. This bill would address the overwhelming need for judges to streamline their courts and continue to maintain standards for free speech, due process, and the right of pro se litigants. Members, I am not an attorney, nor do I try to play one in the Texas legislature, but I will yield for any questions, and I have brought witnesses who are attorneys and who are judges and who work in our court systems that can answer any of these questions as well. And with that, I reserve my right to close, Madam Chair.
Thank you, Vice Chair Plessa. Any questions? No? All right, we reserve your right to close.
Thank you, Madam.
There are a number of witnesses on this bill. We'll do this in panel style again, starting with the first, Eric Carcerano, Adam Schwartz, and Kristen Schemberger. Okay. I'm so sorry if I butchered your name. Eric Carcerano?
That's perfect,
right?
Madam
Great.
Chair.
I have you as self, and you're also here for Chambers County District Attorney's Office, and
That
you
is
are for
correct.
the bill, correct?
Yes, ma'am.
Let me give just a second and see if this panel can be filled out. Adam Schwartz and Christian Stamberger. All right, Mr. Carcerano, if you'd please proceed.
Thank you, Madam Chair. My name is Eric Carcerano. I'm an Assistant District Attorney in Chambers County. I'm here on behalf of the Chambers County District Attorney's Office and myself testifying in favor of HB 2086. We have kind of an interesting, unique interest in this bill. We have, recently we've kind of been burdened by pro se litigants that are literally just trying to grind our system to a halt. We have a particular group of individuals who are legitimately charged with felony offenses, but they file numerous motions to recuse the judge, motions to try and remove the district attorney, judicial complaints, bar complaints. They email the Texas Rangers and the Justice Department every day. They file numerous open records requests, and I realize that's a completely different issue. But essentially what they're doing is their game is eventually, if they complain against everybody, try and have everybody removed, try and have everybody recused, that there will be no one left to investigate them, no one left to prosecute them, no one left to try them. And we're starting to see this more and more. And as a side note, you know, these individuals then get on Facebook and form groups with names like Chambers County Elected Terrorist Mob Removal, and they put these pleadings on Facebook for all the world to see. And none of the things they put on social media are true, by the way. They say things like the district attorney's deceased father, who was a crop duster pilot, was bringing barrels of cocaine into the county, and the first assistant is distributing cocaine, and everyone in the district attorney's office is doing cocaine. Essentially what they're doing is they are just trying to grind the system to a halt. And these are people who are legitimately charged with felony offenses. I think everything that we've done this session has revolved around judges moving their dockets and giving the judges the ability to move their dockets. And I think this gives judges a tool to be able to streamline these situations, to be able to handle their dockets. And I know this bill doesn't solve all the problems, but I think if we can use this bill to start the conversation about vexatious litigants, I think we've done our job. And I'll be happy to answer any questions.
Thank you, sir. We're going to finish out this panel, and then we'll take questions from the entire committee. Adam Schwartz. Yes?
Yes.
Welcome. I have you as Adam Schwartz with the Dallas County Justices of the Peace, and you are for the bill. Is that correct?
Yes, ma'am.
You may proceed.
I wanted to start by thanking Madam Vice Chair and the rest of the panel. I really do appreciate your service. This is not easy work. My name's Adam Schwartz. I'm the Justice of the Peace in North Dallas for Precinct 3, Place 1. I've been authorized to speak on behalf of all of the Justices of the Peace who are very much in support of HB 2086, which allows a court to make a motion on its own to have a hearing to designate an appropriate party as a vexatious litigant, obviously subject to the rest of the rules of Chapter 11 of the Civil Practice and Remedies Code. Passing HB 2086 into law makes courts and dockets more efficient, and it also protects the rights of all of the litigants, both plaintiffs and defendants. Justices in Dallas and across Texas are routinely seeing cases without merit being repeatedly filed against different defendants. The different defendants from the different cases rarely know about each other, but the court can see it. Sometimes the defendants are people, sometimes they're companies. In Texas, if you're a company and you appear in justice court, it has to be through an attorney. So that is more or less mandating a minimum expense of whatever the cost of an initial retainer is every time a company has to defend itself. The rules currently only allow a hearing to be held to determine if somebody is a vexatious litigant if a defendant makes a motion. The court has no power to make that motion itself. Again, the most important point and why the bill is filed is because the situation is such that none of the defendants are going to be able to spot a vexatious situation where somebody's abusing the system we have in place to file unmeritorious cases that ends up costing time and taxpayer money. I'd also like to address some of the concerns that might be voiced by some folks who I think would be in opposition to the bill. I don't see any First Amendment issues or access to justice issues. The bill as written has no detrimental effect on access to justice, nor does it impact a First Amendment right to file a petition to address a grievance. A vexatious litigant is still allowed to file new litigation. They just have to get approval from a local admin judge. That judge has to take a look, make sure that it has merit. That way, we're avoiding having all of these junk cases clog up the courts, and that's what's costing everybody the time and money. This process is already in place, right? And there's no argument that the process is compromised or anything like that. When junk cases clog the courts, it increases wait times for hearings and other important court functions. that other constituents and attorneys expect and deserve to be heard in a timely fashion. That scenario doesn't respect the rights of those people and those businesses, and we can fix that and make government go a bit better for folks. As far as limited resources go, the courts have limited resources, including time, money, and personnel, right? And when those valuable resources get expended at a 10-to-1 ratio, which is about what it takes to deal with one of these cases getting filed in the way that they're filed, often hand-filed with a large number of attachments to them, there's like 10 cases that we can't scan, process, upload, and those resources can't be utilized in furtherance of other cases and constituents whose rights have now been delayed. And as some very important people have said famously, justice delayed is justice denied. Addressing a possible concern about court overreach, real quick, Section 11.101C guarantees an appeal from a pre-filing order designating a person as a vexatious litigant. Appeal rights are preserved. Section 11.053 guarantees fair notice and a hearing to determine if someone is a vexatious litigant. A court can't just slap that designation or label on someone whenever they wish without due process. Same as now. This bill just gives the judge an opportunity to make the motion instead of waiting for a defendant to do so. No one's stopping anyone from having their day in court except the folks filing meritless cases over and over again. That's who's that's who's delaying justice in this scenario. Passing HB 2086 into law makes courts and dockets more efficient and protects the rights of all of these litigants. I want to thank everyone again for their service, your time, and your support of this bill. I drove down here from Dallas in the rain today because this matters to me. This really matters to the court. It matters to courts really all across Texas and to everyone who's not one of these litigants and who's waiting for a hearing because of them. Y'all's support of this bill is the support of more efficient and more effective government. It respects the time and interests of people and businesses throughout Texas while protecting due process rights across the board. I urge y'all's favorable support of this bill that should come out of this committee, get a vote on the floor, and go to a signature from the governor. I'm available so y'all can pepper me with whatever questions y'all have about what happens in my court, the people that we get to see, or anything else really y'all like to talk about. I'll yield the rest of my time. Thank you.
Thank you, sir. We're going to finish out this panel and then take questions from the committee. Ma'am, Ms. Schamberger, would you spell your first name for me just to make sure we have it correct in the record?
Christan.
Okay, great. Kristen Stamberger, I have you here for yourself and you're for the bill, correct?
Yes, ma'am.
Thank you.
Good afternoon, Vice Chair Johnson and committee members. My name is Kristen Schamberger, and I'm the Chief Clerk for Dallas County Justice of the Peace, Precinct 3, Place 1. While I am here testifying on behalf of myself, I'm one of hundreds of clerks in Dallas County and one of thousands across Texas that deal with vexatious litigants on a daily basis. I want to start off by saying that I love my job. Justice courts are called the people's courts for a reason. Most people's first and only encounter with the judiciary is going to happen in a justice court, whether it's a traffic ticket or a small claims case. Our court in particular takes pride in being for the people. We have dozens of resources available on our website for plaintiffs and defendants alike. Self-represented litigant packets are available free of charge to anyone who needs one, and we're always happy to spend as much time as a litigant needs to answer questions about the process or filings. As the second largest justice court in Dallas County, we're allocated 10 clerks with 5 dedicated solely to civil cases, but we're in a constant state of catch-up. After launching electronic filing last January, we consistently receive 150 to 200 new civil case filings every week and up to 300 misdemeanor filings. In 2024 alone, we processed almost 20,000 new case filings, in addition to the thousands of backlogged cases left by the previous judge, some dating back to 2016. Trials in civil cases are often set out 6 to 9 months in advance, and we just had to schedule an additional day for the ADA to come in for misdemeanor cases. When vexatious litigants come in, they generally take on average 45 minutes, sometimes up to an hour and a half to help. They're people that while they file 1 to 2 cases a month, they're still not familiar with the filing process and often have to make several corrections to their filings before they can be processed. In the time it takes to help one vexatious litigant, our clerks can set 10 cases for trial, process 5 new cases, and respond to a dozen emails or calls. This doesn't even count for issues with service or pretrial or post-judgment filings. We're always looking for new ways to make our processes more efficient and justice more accessible for the residents of Dallas County, but it becomes increasingly difficult when we're faced with individuals who are repeatedly filing cases without the proper procedures or show a clear understanding of the legal process. These individuals often burden the system, not only slowing down the work for other litigants, but also consuming a disproportionate amount of staff time and resources that could be spent addressing the needs of other more pressing matters. While everyone has a right to access the courts, it's important to recognize that there needs to be a balance to ensure that the judicial system remains effective and efficient for all. As I said, in Dallas County, we pride ourselves in providing accessible legal processes, but when a person becomes a vexatious litigant, their filings become an overwhelming challenge for clerks like me, which detracts from the time we can devote to other essential duties. We understand that the legal system is complex, and many people come into it without a full understanding of how it works. That's why we make every effort to assist people, even those unfamiliar with the filing process, but the volume of cases filed by vexatious litigants sometimes makes it extremely difficult to maintain a smooth operation. More resources and a more structured approach to dealing with these individuals could allow us to better allocate our time and improve the overall efficiency of the court system. At the end of the day, we want to ensure that everyone has equal access to justice. However, without an effective means to manage and limit the actions of vexatious litigants, we risk overburdening the system and delaying the timely resolution of cases for those genuinely seeking justice. Thank you for your attention and for considering the challenges faced by clerks like myself and the judiciary as a whole. I appreciate your favorable consideration of HB 2086.
Thank you all for your testimony. Representative Schofield.
All right, thank you all for being here. As you know, the current law, I think since 1997, recognizes the court's ability after a hearing to rule that the litigant is vexatious if there's a motion from a party. And this bill, the change it would make was the judge could do it on his or her own motion. And Mr. Schwartz and Mr. Carcerano, you each said something that made me see it in sort of bold relief. Mr. Schwartz, you said that a lot of the times the vexatious litigant is firing off pieces of litigation at different defendants who wouldn't even know each other.
Right.
So no one defendant, as I understand your testimony, don't let me put words in your mouth, no one defendant would see enough of this to file a motion, but the court sees all of it. Is that basically what you were explaining to us?
That's a spot-on analysis, yes.
Okay, can you give me an example of something that you've seen either in your court or just in practice?
Let me give you two. Two different litigants. One of them has filed 7 cases since the beginning of the year. 5 of them have already been dismissed. 2 of them are still open. None of the defendants are the same people. None of them have any kind of correlation to one another. The other person filed, I think, 8 cases last year, and of the ones that they filed so far this year, I pulled suits against Goodwill Stores, suits against the Carrollton Police Department, 2 different apartment complexes, Dallas County Housing Authority, and then I can recall suing McDonald's, Hewlett-Packard, and a number of other places. And none of them have any idea that anybody else is involved in any kind of litigation, much less the plaintiff who's filing 10 cases.
So none of those defendants individually would be likely to file this motion.
Correct.
But the judge sees all of this.
Correct.
All right, and that again, it makes me see it in a different way because I think of a vexatious litigant as someone who's harassing an individual or a company or somebody they don't like, and they're repeatedly suing them, and that person is feeling the burden of it and the cost and the expense. But you're telling me it's really, in addition to that, there's all of the burdens on the court's time and the court staff's time dealing with what you can see is a vexatious litigant, even though no one defendant would think that.
Yes, sir. There's an additional scenario that's come up where somebody has been filing cases over and over again, does a statement of inability to afford the costs, so the county takes on the cost of filing it. They never actually serve anybody. Just about a month, maybe 6 weeks later, they go ahead and non-suit the case and dismiss it. I don't know what their reason for doing that is, but
other than just to harass the court and make you run around and chase your tail.
That's kind of how it feels, but it could very well be there's just something going on interpersonally with that person that doesn't have anything to do with us, but this is their outlet. I'm not sure it's an appropriate outlet for them to be using. It's another reason why I'm here.
And Mr. Carcerano, what you said, I didn't really put it together till what Mr. Swartz said, but you were talking about either defendants or people who have issues in your court who are trying to disqualify everybody they can think of. So they're individually suing different people.
Yes, sir. That is the exact situation. We have a particular individual, and this individual is legitimately charged with a first-degree felony that was presented to the grand jury, that is set for trial, that we've been trying to get to trial for a long time. And he's on his, well, he's been through about 3 or 4 lawyers. Now he's pro se. We're on about our 4th visiting judge because he files judicial conduct complaints, motions to recuse, tried to recuse the judge of the administrative region. The motion to recuse is now pending before the Chief Justice of the Texas Supreme Court because there's a procedure where you can actually take a motion to recuse to the Chief Justice of the Supreme Court. So that's pending there.
So no one of those defendants, under the current law, before Ms. Palazo's bill, nobody would really be likely to seek relief because they only had 1 case filed against them. But the court can see, okay, I'm seeing a plethora of cases, and then again, nothing changes in the current law that the I don't even know what we call the vexatious litigant when they're not a defendant, but that person, the respondent, I guess, if we're gonna, the respondent still has a right to a hearing, still has, so the judge just doesn't go, you're vexatious, no more filings for you. They get a hearing. If they're found to be a vexatious litigant, they still don't lose their access to the courthouse. But before we go through all this, the judge or a judge is going to look at these and determine whether, okay, you might have been a vexatious litigant, but this time you actually have a case.
Right.
Or you may have a legitimate claim of some type.
Right, and we just have to give them fair notice before that so they have time to be able to prepare a defense and prove up that maybe they aren't a vexatious litigant.
So without this bill, neither of the 2 types of circumstances that you're talking about would likely be remedied under the current law.
Not a single person has filed one of those motions since I've been on the bench.
Please pull the microphone.
Sorry. Not a single person has filed one of those motions since I've been on the bench, and it's been a number of years now.
Thank you, Madam Chair.
Thank you.
Thank you,
Chairman?
Madam Chair.
Chairman Dutton.
Thank you, Madam Chair. In Texas, the vexatious litigant is somebody who has no reasonable probability to prevail in the current litigation. Is that generally right?
That is correct.
Should that apply to defendants too?
Are you talking about, defendants are generally the ones being sued, not
Well,
doing the suing.
I understand, but suppose they don't have any reasonable expectation of winning the lawsuit.
They still have a due process right.
Well, why wouldn't the plaintiff have that?
They do. That's why there's an opportunity for a hearing and fair notice for that hearing. The problem becomes when they're abusing the system, right, and filing over and over all of these cases and show a pattern of having no merit for those cases. At that point, it seems like in the interest of judicial economy, if nothing else, to put a tag on that and say somebody should take a look at this first before we just clog the courts over and over again. They still get the chance to file that litigation. No one's stopping them from doing that. They just have to get an okay first because they've already established a pattern.
I don't mean to cut you off, but
Sure.
I understand that. Having practiced law for almost 40 years.
Sorry, I meant no disrespect.
And so I'm just curious about, well, let me ask this. Does a vexatious litigant have a right to appeal?
Yes, they sure do. The code gives them that right in section 11.053.
That's what I
I'm sorry,
thought.
101C.
And so what we're doing with this bill is creating probably more work for the appellate court.
How do you
Because-
figure?
Well, if the court determines that they're a vexatious litigant, and that's what they are,
I see.
they're more likely to then file an appeal with the appellate court.
I see that as trading one appeal for five, at least with the litigant that I was talking about. They have a right to an appeal on any of those cases that get poured out of court for whatever reason. Same as they have a right to an appeal for a pre-filing designation of them as a vexatious litigant. It's just what rights they choose to exercise.
So you don't think they would, being a vexatious litigant, they would exercise the right to appeal?
I'm a little unclear on the question.
Well, the vexatious litigant, you agree, has the right to appeal, correct?
Yes, sir.
Okay, and these are people who have been filing all kinds of stuff in a court, correct?
Yes.
And nothing in this bill or in the current law prevents them from filing an appeal, correct?
Correct.
Okay, so why wouldn't we expect that they would continue that now in the appellate court, which they were not doing in the lower court, which this bill prevents them from doing?
They have every right to pursue an appeal either of the designation of them as a vexatious litigant or if a case gets poured out of court.
I'm not talking about the right, sir. That's not what my question is. My question is,
the
why wouldn't we
likelihood of them doing
expect
it?
them to do that? If they're a vexatious litigant, they're gonna be filing all kinds of suits. Now we're gonna say, we can halt that in the lower court, but shouldn't we expect them now to jump over into the appellate court?
Oh, I see what you're saying.
Thank you.
I don't know that the code directly addresses what happens if somebody tries to file new litigation and doesn't get the approval from the local admin judge.
They
I
would
didn't
need
see
the,
anything.
would they need the approval to file an appeal? I don't think so. That's not what
I
the
don't-
statute says.
I don't think so. I think that just gets poured out of court because the admin judge determined it has no merit.
Right, but then they could appeal that, correct?
That's what I'm unclear about. I didn't see anything that says it that way.
I'm not sure I understand your answer.
It's closer to no than yes. But kind of like a lot of attorneys, I think the answer is it depends.
Well, but the
I don't
statute
believe-
allows them the right to appeal, correct?
It allows them the right to appeal the designation as a vexatious litigant.
Correct. Correct. So, and I guess what was bothering me is, well, let me get to the point. If we're gonna do this, I think we ought to take a look at making sure they don't exercise any appeal rights, or if they do, a limited sort of appeal right.
I think a smart move is talking to an appellate law expert for sure.
Yeah, that's what I'm suggesting, because we could literally expect them to now jump over into the appellate courts with filing all kinds of things because they've been designated a vexatious litigant in the
Sure.
lower court.
Yeah, they do have that right now. What we're asking y'all to support doesn't change any of the processes that are in place. It just allows the judge to make the initial motion. That's
Right,
it.
I got that, but anyway, I'll talk to the author about the bill.
Looking forward to it.
Thank you. Any other questions for this panel? Representative LaHood.
Just briefly, thank you, Vice Chairwoman, Madam Chairwoman. I'm still learning all the formality. I just wanted to say, please give my warmest regard to Judge Kane. Is he still in the 253rd?
Yes, sir. Yes, sir, absolutely.
Excellent judge, great court, efficient, effective, and respectful. So please pass on my
He's-
regards.
He's in the middle of all this too, so.
I believe it.
It's really burdening our courts right now, and like I said, if we can start having the conversation about how to give our courts some relief in this situation, it would be extremely helpful.
No, I'm glad you testified because I was talking to Plessa representative before about some of my concerns, and y'all brought up analogies or situations that really made sense to me, and it eased my concerns. So thank you all very much for everything. Thank you.
Thank you. Any other questions?
Madam Chairman.
Representative, or Vice Chair Hayes.
Thank you. When I look at the section 11054 of the Civil Practice and Remedies Code, which is entitled Criteria for Finding a Plaintiff a Vexatious Litigant, it gives us three alternatives. And the first says the plaintiff in the 7-year period immediately preceding the date the motion is filed, has commenced, prosecuted, or maintained at least 5 litigations as pro se litigant other than in a small claims court. All right, number 2 is, after litigation has been finally determined against the plaintiff, a plaintiff repeatedly litigates or attempts to relitigate, pro se. And 3 says the plaintiff has previously been declared to be a vexatious litigant. So in listening to your testimony, because many of your concerns seem to me not only involve litigation that is not likely to prevail, but it's stupid motions that are filed. And so, do y'all have any recommendations on, because inside the lawsuit itself, there could be a series of just frivolous, bad faith motions that wouldn't qualify as an action under the definition, under this section of the Civil Practice and Remedies Code?
If I may, I think this gets us closer to where we want to be as far as filings go. I realize we talk about separate actions, but I'll kind of give you an example in our situation. We have this particular defendant who files motions to have the district attorney removed from office. He will file that motion, will bring in a visiting judge. That visiting motion will deny the judge, will deny the motion. The next day, he will bring in his girlfriend to file the same motion. And then he'll bring in his brother and his neighbor. And those are types of situations, and then then he'll file another motion with a different date, these kinds of things. So under the literal definitions that are in the code right now, those are all separate people, and that's one action by several different people. But I think the spirit of the statute should be able to get a judge there to a judge where a judge can say, no more, this is it, we're not going to hear this matter again.
Okay. My second question is, under the second example of how you can have someone deemed a vexatious litigant, because number 1 said five actions in the last 7 years.
Yes, sir.
Number 2 just says the plaintiff repeatedly relitigates or attempts. So what is y'all's experience and what does repeatedly mean? Is that 2 times, 3 times, 4 times?
That's the situation that I was just bringing up. We've had, you can look on this and to address the issue that I'm sorry, Chair Dutton has gone to address his issue. Our matter's gone to the court of, our matter has gone to the 14th Court of Appeals, and our vexatious litigant files hundreds and hundreds of pages at the Court of Appeals because every motion itself becomes an attachment to the next motion that he files, and these, pretty soon you have hundreds and hundreds of pages, and at the end of the day, he does nothing. He just keeps filing motions, asking for the same things over and over again at the Court of Appeals, and I think eventually the Court of Appeals finally shuts him down. But in our situation, this defendant's, and I attribute it all to him, even though there's 4 or 5 people filing these pleadings. He's probably filed 30 or 40, and they all say the same thing, do the same thing, and none of it has any merit.
Okay. Judge Schwartz.
So for our experience, it's a little bit different, but along the same lines, right? I'll end up having, usually it's a small claim or a debt claim where somebody has had the case heard, they didn't really like the ruling, and so they'll try filing it again. To me, I feel like somebody should get one free bite at the apple in case it's a mistake. So unless something happens a few times and I can establish a pattern, I'm not really raising an eyebrow to it. The concern I would have that I'd want to clarify is in cases like evictions. I don't think this would be applicable to a situation like that for two reasons. One is because different interests accrue as time keeps going on, right? For even just in monetary terms for back rent, for example. But beyond that, there's a specific carve-out for eviction cases where res judicata, civil double jeopardy just doesn't apply. Those cases can be filed again and again, and it's explicit. So for these purposes, I think somebody who has just disagreed with the court's ruling and keeps going back again and again and again, that's how I'd read provision number 2 in that section.
Thank you.
Thank you. Members, any other questions? Thank you all again for your testimony and your time.
Thank
The
you.
next panel will be Peter Beasley, Steve Wofford, and Brandon Johnson. Again, Peter Beasley, Steve Wofford, and Brandon Johnson.
Thank you all again.
Thank you. Mr. Beasley?
That's me.
Great. I have you as Peter Beasley. You are
Yes.
here for yourself and you're against the bill.
Yes, ma'am.
You may proceed.
Hello, thank you, Madam Chair, Vice Chair, and members of the panel. And I am not a lawyer, and I don't know if I'm the only one in the room who is on the vexatious litigants list. And so I feel coming in here with so many lawyers and just hearing the last panel, this is going to be a little bit more difficult than I thought. So many of you, we all watch TV, and so we know who the Texas Hammer is and the law boss and whatnot, but I could probably also be called the vexatious litigant because the vexatious litigant statute allows the judge to impose a bond amount. So if you wanted to continue that same litigation, you have to pay that bond amount. It's a security amount. And typically, I'm in Dallas County. If you look on the vexatious litigants list, I'm listed there since 2018. Most of the bonds are $1,500, $5,000. The highest, other than mine, is $20,000. Mine is $422,064. So in one hearing, the judge said if I wanted to continue that lawsuit, I had to pay $500,000, basically. And this legislation, as it already exists, does allow that to happen to any human being, that the security amount, there is no checks and balances on that. In my case, there was no evidence entered. And the legislation, if you look at the criteria for becoming found a vexatious litigant, there must be 2 findings, as was mentioned earlier, 5 failed lawsuits in the last 7 years, and there's no probability to win the current lawsuit. My one sheet of paper made none of those findings because they're not true. That's not on here. Most are on the vexatious litigants orders that will list the cases that they had before. And I've seen some of those orders, and they are very long because some of those people have filed and lost a lot of lawsuits. Mine has none of those. So I hear testimony about specific people, and the analogy I got was there was this one Jewish person that filed a lot of lawsuits, so let's keep all the Jews from filing lawsuits, and or a black person. I heard because there were some problem people. I am on the list, and I think it is needed legislation, but it needs to be fixed first. There are so many unconstitutional, not a lawyer, so many gaps in that legislation, so determining what is a litigation can be blurred. Using mandamuses as a failed litigation when it didn't finally decide anything, that's a problem. If you do the math, and I'm an electrical engineer from UT Austin, went to UT Austin, a lawyer told me in my fight to deal with this problem that I now have in my 60s, that it's a legislation that's been used to segregate people. And so I did the math in Dallas County, and 72% of the people that are put on the vexatious litigants are black, turns out. And so you'd have to do, look them up. You can look at their filings. You can find their phone number. I've talked to most all of them, and since I've been on the list, I've interviewed, and so I have the racial breakdown. The most vulnerable are black women that end up put on there. Seemingly more so, black people in Dallas County are only 24% of the population, so how could 72% of the people on the list be black? And we are not likely, in civil court filing lawsuits, more so than people who are not black. Also, in my case, I was not the person who filed the lawsuit. The defendants filed the lawsuit. And so you're supposed to be the plaintiff. How about that? You're supposed to have 2 findings. I didn't have that. And then a $500,000 security amount, so it made it impossible. There were so many items that I heard in the prior panel that were incorrect, that was stated, that no one judge would be able to see all of those patterns. These people could be filing lawsuits in different counties, in different courts, so it's not that that judge would see that pattern. Also, the judge would become the prosecutor and the judge and the juror, because typically there is a defendant who files it, and they will have to pull all the records together and submit those. So I guess the judge has to investigate the person, find all of the cases, the judge submits them, and then the judge rules on it. And you'll find that if you're on that list, again, I don't know if anybody in the room is on it, you can't hire a lawyer because lawyers don't like to represent vexatious litigants. Your lawyer will soon find out that, guess what, they can't sue you because they can't file a lawsuit. The local administrative judges who may allow you to file a lawsuit is permissive. It is not, if it's found to not be frivolous, they must let you. It is permissive that they may let you. So you could never appeal that because it's an appeal by mandamus. And so you could never find an abuse of discretion if the local administrative judge does not allow you. There are so many other loopholes. I don't know where I am, my 3 minutes.
If you're about ready to wrap up, that's great.
Let's see here. The right to appeal is very, very narrow. Yes, the person adjudged to be a vexatious litigant has an accelerated interlocutory appeal that they can make, but they would not know that typically. They will lose that right, and then you lose your lose rights for all of your life. If you are found a vexatious litigant, you can never get off the list. In some states, you can get off of it in a period of time. The governor cannot pardon you. You can be a murderer and get pardoned, but if you're a vexatious litigant, it's that way for the rest of your life in Texas, which is not good. And there are many ways to fix the bill other than allowing the judge to just sua sponte, call a hearing, and then declare someone a vexatious litigant. You could extend the time for someone to file that motion. It's 90 days, and it could be extend that to 120 days or 6 months if they feel the person might be a vexatious litigant. There's many other ways that are protecting of those people that could actually not be a vexatious litigant or shouldn't be found to be one.
Thank you, Mr. Beasley. Also, let the record reflect Speaker Pro Tem Moody is present. Mr. Johnson will take your testimony and then open up the panel for questions from the committee. Mr. Johnson, I have you as Brandon Johnson. Here is yourself, and you are against the bill. Is that correct?
That's correct.
You may proceed.
Okay, and I want to say I sympathize with the previous panel because I've actually been sued in federal court by what I would call a vexatious attorney. But since attorneys don't get held accountable, this bill would not apply to them. And we did prevail in that, myself and another pro se litigant, we did prevail in federal court, which I know that's different from state court, but nonetheless, this is actually a silver bullet bill against pro se litigants, is what this is. And what you have is a DA and these judges asking for protection against the people. The courts are supposed to be open to the people, and they're trying to shut it down. And they gave a couple of examples, but the reality is There are a lot of people who cannot find a lawyer because what happens is the lawyers will manipulate the laws that y'all have written. But when pro se litigants want to challenge those laws, there's not an attorney in the state of Texas that will do that. And therefore, many people find themselves in a position where they must move forward as a pro se litigant when they would prefer to have an attorney. The law is a monopoly, and we're not part of it. George Carlin said that, right? It's a big club, y'all, and we're not in it, those of us on this side of this thing. So there is no remedy. It's tyrannical and it's oppressive. There's a lot of buzzwords that have been used in this committee, talking about efficiency, effective, judicial efficiency, and stakeholders. But what's not included is the people being a stakeholder in the laws that y'all are passing. And therefore, I thank you for allowing me to testify.
Thank you, Mr. Johnson. Members, any questions of this panel? Thank you both very much for your testimony and your time. Again, Steve Wofford. Okay, moving on to the next panel, George Saldana, Chapman, and Cody Taylor. George Saldana, Chapman, Cody Taylor. Mr. Chapman, if you'll help us again by giving us your full name if you'd like to testify this time. Charles Bryce, and we have your permission to make the change in the record, correct? Yes, ma'am. Thank you so much. Mr. George Saldana?
Yes, ma'am.
I have you here on behalf of yourself, and you're against the bill. Is that correct?
Yes, ma'am.
You may proceed.
So we talked about patterns, and one of the things that I saw in the first, panel is 3 legal officers of the court talk about pro se litigants. I'm not a lawyer, but I've done some reading, and I believe in 2025 we can look up everything that lawyers can pretty much look up, and legislative intent is how the law is written. I think we can decide, some of the things that we're reading that doesn't need to be interpreted. But what they targeted was pro se litigants, and I see their perspective, but they have to see our perspective. And I come from family court, where I'm going to be point blank. Some of these judges, they're morons. Just because they're elected does not mean they can not fulfill their legal duty to the people of Texas. And in Harris County, we have judges that are actively removing constituents from their courtroom, using the bailiffs to push us out. That's First Amendment. That's like bare fundamental law, right? Courts shall remain open, and you have 2 district courts in Harris County pushing people out. Bare fundamentals. I've asked for a habeas, I was denied. I had to file 3 enforcements because the judge would not set a hearing for me. The family code says shall set a hearing. The judge shall set a hearing. And the judge wouldn't set a hearing. So when you give these judges power to sua sponte and just say you're vexatious, I've lived that. And I'm the respondent in family court. I'm fighting to see my son. Not only that, but I have a compelling state's interest before the state starts limiting my fundamental rights as a parent. I have a duty for care, control, and protection of my child. Now you're going to limit me filing, and whether it's a petitioner, a respondent, defendant, whatever it is, it's going to affect people, whether you're in probate court or family court. And I'm coming from the family court side. I could see the issues that they're having, and I can see their perspective when people are tying up the system. But when you have pro se litigants that are actually fighting for their children, and we have judges that are just ruling rogue, wielding their discretion, and we all know it. The SCJC has problems. There is no oversight for these judges. And when there's no oversight on these judges, those judges are free to make those rogue rulings, which would put you in a very difficult situation if you're trying to litigate for your child. And I'll end with that.
Thank you, sir. Charles Bryce Chapman, have you here on behalf of yourself and you're against the bill, correct?
That is correct, yes, ma'am.
Please proceed.
I've been, well, I guess like this man here, I've been in family court where I have had 6 or 8 judges recused off of a case based off of a constitutionally disqualified judge who represented the opposing litigant on the same matter controversy. If they're going to try to make a pro se litigant a vexatious litigant, what about making the judges vexatious judges and vexatious attorneys? I've tried to hire over 4,000 attorneys for my case, been denied. All these judges that I have had on my case have been retired judges. And there's no accountability for these judges, and there's no sense in if a man can't defend himself and he has judges that are working against him for, in my case, special interests, there's no sense in having a vexatious litigant bill passed, because it basically just takes all your rights from you, and I yield.
Thank you, sir. All right, and I have you registered as Cody Taylor, representing yourself today, testifying on the bill?
Yes.
Is that correct?
neutral.
All that's correct?
Yes, neutral at this time.
Understood. Okay,
Yes.
go ahead and begin your testimony.
There's some literature being passed around as if y'all don't have enough words to read, so I add a little bit to your daily routine. I'll let those get passed out for just a second. I was hoping everybody would be in panel for this small speech. I believe you're going to lay that out before you leave? Okay. So in this packet that you'll see in front of you, there's a couple of things, comment that I will explain, but if you would turn your attention to the second page. So the second page is what Representative Pleasa and I have discussed, and this is primarily due. So with all due respect to the people who did come down here to testify, I drove from Beaumont, so I'm 4 hours plus in this weather and traffic, but you have a specific cause, we as well. In Texas family courts, we are not protected once we get into the pro se matters. And if any of you have been around it, I was here last week and the week before testifying, but if you have been around it, it can cost tens, if not hundreds of thousands of dollars, and I know of some that have been millions into their litigation, which then forces common layperson to seek to do it themselves. This is the email that I sent to Representative Pleasa in regards to this. In Texas Family Code, if you are deemed a sole managing or a joint managing conservator under 151 and 153 of the Family Code, you have certain rights, some that are sole and then others that are joint. If you are deemed a vexatious litigant and it coming out of family court, and let's take away the civil cause or the criminal cause to that, you have lost a very substantial reason as to why you become pro se to zealously, right? That's in ABA. Zealously fight for your child or your rights. I can't stress this enough, that there should be, and for what we've discussed with Representative, is that there should be exclusions to this chapter. This chapter should not include a parent or anybody that falls underneath Title I or Title V of the Family Code. Being that in the family law, in the Family Code, you can come to court for many reasons after divorce. Divorce is one of those, but there can be multiple reasons as to petition the court to make changes, modifications, child support, or other reasons. If you're deemed a vexatious litigant, when you're going through family court, there's a ton of reasons as to why you may turn pro se. And I can attest to a lot of the stories that have been heard over the last 3 sessions that I've been a part, that there's a lot of judges out there in family court that absolutely do not uphold the law. I would ask you to turn to page 3 into that packet. You can see the SCJC reprimand of the judge that was in my court case. So I'm gonna give you a scenario, and understand I drove for a while, and I'm speaking on this so you can have a full picture as to why we're asking for this change in this code. I'm not gonna take up too much, Chair Leach. I was filed in 2019 against me, so I was the defendant or respondent in family code. So I was not the plaintiff or the petitioner in this matter. I'm forced to defend my rights to my child. That lasted 3+ years. At the end of it, I was a joint managing conservator by a jury. However, the judge decided to take my rights away in specific terms. Now I'm forced to go through the appeals process. So I'll put it to you this way. If that judge would have not aged out and he wouldn't have been recused on other matters, he would have continued to violate everything about what I stand for, including years before where he called me one of the best parents to walk through his door. Fathers primarily. It's amazing what can happen in inherent bias whenever you walk through family court. But he was sanctioned. Imagine if a vexatious standard would have met his doorstep and where I would have been today. I also want to make you turn to, or have you turn to, the last portion of that packet, which is what Representative James White asked Attorney General Ken Paxton at the time, and what he was asking for is that it's fundamental right for a parent. I understand your cause and why you're here, but in family court, this is why we're here, to protect the fundamental rights of parents. Unless you don't have sole managing or joint managing conservator rights to the child going through child custody, I don't think any of that should ever be underneath the stipulation of a vexatious litigant. Primarily because there's no time limit to get off for a parent. So let's say that you do get vexatious, there's no way that you can have an annual review other than an appeals process. There's actually, when you ask the court to then, if you're on the vexatious, to say, I want to file that, become the plaintiff petitioner in that matter, that judge doesn't have a time frame as to when they actually can rule whether you have merit for a case or a cause. That there needs to be something potentially inside of that if we're going to continue down this path without specific exclusions in family code. They need to make at least a 90-day, 120-day, some type of ruling so that the appeals process or mandamus process can start, right? The other side of that, too, is family court cases
Hey, sir, I got to ask you to start to wrap up your testimony.
sir.
We're
No.
listening and we care, but we've got other bills with multitude of other witnesses. So
Yes,
if I
sir.
can get you to come to a stopping point.
Yes, sir. There just needs to be a standard, and I believe she's going to lay that out. Is it Title I, Title V, and anybody inside of child support should be under the family court, excluded from the vexatious side of this standard. I appreciate your time.
Yeah, thank you. Thanks for your testimony. Members, any questions? Okay, thanks. Appreciate y'all being here. Does anyone else wish to testify on for or against House Bill 2086? Okay, seeing none, the chair recognizes Vice Chair Plesa to close on the bill.
Thank you, Mr. Chairman and members, for the opportunity to lay out this bill before you today and for the opportunity to strengthen protections against vexatious litigants in Texas, making our courts more efficient and saving taxpayers money. I would first of all like to thank everyone who showed up to testify on for or against this bill, but I also want to apologize for some of the comments that were made against our attorney friends, judges, and those who work in our court systems. With that, I'd be happy to answer any questions you guys might have. Hope for your favorable consideration on 2086. And with that, I close, Chairman.
Thank you. Vice Chair, members, any questions for the bill's author? All right, thank you.
Thank you.
Appreciate you being here.
Thank you, Chairman.
The chair will leave House Bill 2086 pending at this time. The chair now lays out House Bill 3441 by Representative Luther and recognizes Representative Luther to explain the bill. Welcome.
Thank you, Chairman Leach and the members of the committee. I appreciate the opportunity to lay out this bill. As many of you know, COVID brought a new awareness of the risks and problems with blind trust in pharmaceutical companies and in our government. Currently, due to the National Childhood Vaccine Injury Act of 1986, vaccine manufacturers hold no liability if a vaccine or countermeasure harms or injures a Texan. And now there are limited avenues for seeking compensation from the federal government. There are very few instances where a government provides this level of blanket immunity to any company. I have spoken to thousands of families from both sides of the aisle who either don't vaccinate or adhere to what's known as an altered schedule, and the fear that comes from knowing that the company producing these medical products holds no accountability is often a large motivator in their decisions. So today, if you're on this committee and you want everyone to get vaccinated, I believe that this bill will provide peace of mind for concerned families. If you're someone on this committee who supports vaccine choice or is skeptical of the science around vaccines, this bill seeks to provide the same kind of accountability that other companies have. This bill simply states that if a vaccine manufacturer chooses to advertise in the state of Texas, they should be liable for actual damages, reasonable attorney fees, and court costs if it is found in court that the vaccine caused harm or injury to an individual in this state. I will tell you, we're anticipating a committee sub. We definitely want to more narrowly define what it means to advertise in the bill and make clear that we're talking about TV ads, digital ads, radio ads, and over-the-top TV, which are paid for by the manufacturers. We have no intention of preventing doctors from being able to hand out pamphlets in their office, nor the ability to encourage their patients to be vaccinated. This bill does not debate whether someone should be vaccinated. It simply states that if a vaccine manufacturer would like to advertise their safe product, they should also claim responsibility for injury. Again, thank you, Mr. Chairman and committee members, for hearing this bill. This is my first bill layout ever in front of some very well-respected legal minds, so it's a little scary. Just wanting you to know it's a little intimidating. But I'm looking forward to getting feedback from all of you, especially on the committee sub. If there are any questions I can't answer, I have some folks here that will be testifying who should be able to give you more information, and I am happy to answer any questions, and I respectfully reserve the right to close.
Did you say well-respected legal minds?
Do you know where they are?
And Representative Schofield is here too. And so, members, any questions for the bill? It was a great layout. Congrats on your first bill. Members, and you picked quite the doozy for your first bill.
You did, sir.
Members, any questions for Representative Luther? Okay. Thank you. We'll move on to witness testimony. You've got a handful of witnesses. Let me call two panels of three witnesses. The chair calls Dr. Mary Bowden, Jackie Schlegel, and Paul Hale. I'm not sure I see Jackie. Michelle Evans. Is it Bowden or Bowden? I've always wondered.
Bowden.
Bowden, I said it right. Is Mr. Paul Hale here? Okay. We'll show Mr. Hale is registered for the bill but not wishing to testify. Is Mr. Lee Parsley here? We'll show Mr. Parsley as on the bill but not wishing to testify. Is Jackie Schlegel present? We'll show Ms. Schlegel is registered for the bill but not wishing to testify. And so, Dr. Bowden, let me recognize you. I've got you registered on behalf of yourself, registered for the bill. Is that correct?
Yes, sir. Thank you.
All right, go ahead. Welcome.
So I'm a ear, nose, and throat doctor in Houston, Texas. I treated over 6,000 COVID patients during the pandemic. And in the aftermath of the pandemic, the biggest issue I see with my patients is lack of trust. A recent Gallup poll showed that only 17% of people have moderate trust in our healthcare system. And a lot needs to be done to restore that, but I support HB 3455 primarily because I see this as a step in rebuilding trust. The lack of transparency and accountability surrounding the events of the pandemic led to widespread vaccine hesitancy. I see it all the time in my practice. And I believe, with good reason, vaccines are not subjected to the same scientific scrutiny that other medical products are subjected to. Because they enjoy 100% liability protection, The manufacturers lack motivation to exercise the scientific rigor they might exert for a product they could get sued out of existence for. The state of Texas enjoys the distinction of becoming the first state to support and encourage COVID-19 shot mandates. The CEO of Houston Methodist Hospital bragged about our state, about our governor encouraging everybody to get a shot. And Texas became the first to instill mandates 5 months before Biden did that. The same day that Methodist announced that it was mandating the shots, Biden announced the deployment of the COVID-19 Community Corps. This is $11.5 billion, and it was all going towards advertising, all going towards community groups, influencers, to get people to get these shots. As it stands, all babies are expected to get 3 mRNA shots by the time they're 9 months old. That is on the pediatric vaccine schedule. I have seen tremendous problems with this shot. 7% of my new patients in the 2 years following the rollout of these shots, 7% were coming to see me for injuries. I've never seen anything like it with any other product on the market. These people have chronic debilitating issues, and none of my patients who have come to see me with these injuries, and they came right after the shots, they were otherwise healthy, extensive workup, $1 million workup, and nothing can be found. And they're suffering a lot. It's a big deal. None of them were reported to VAERS. I had to report them to VAERS. And they're very difficult to treat. And I only heard back from the government in 2% of the people that I reported to VAERS. So VAERS is failing. Breanne Dressen was an injured patient. She volunteered to get the shots. She actually started a big group, React 19, because to help all the people injured by these shots. And a couple of weeks ago, she was denied compensation for her injuries, and she has really been through a lot. So I see this bill as an opportunity for the state of Texas to redeem themselves after these mandates and to lead the country. This is a common sense bill that promotes fairness and transparency. Thank you.
Thank you. Thank you, Dr. Bowden, for your work and for your testimony today. I had a conversation yesterday in my office with Representative Luther about this, and I have some questions that I'm not sure we have. I'm going to ask you, but I'm not sure you're the right witness to ask this to. But I'm going to ask it anyways. Who owns the airwaves in Texas? So and who has control over the airwaves in Texas? And so when it comes to advertising, I'm thinking, for instance, the Super Bowl. Okay, and if a drug company pays for a Super Bowl ad to to advertise a certain vaccine or whatever, pays whatever it costs now to do a 30-second ad, that is broadcast nationally. What authority, if any, does the state of Texas have to not air that ad on our airwaves here?
I have no idea how to answer that.
Okay, and so my question, just logistically, and I know Representative Luther is going to look into this, is if we're going to go down this road and have this conversation, I want to have a better understanding of what sort of does the state of Texas, do we have the ability here to keep certain ads off of our airwaves? I imagine that we do. I know we do, but I don't know how that works. Representative Schofield.
Mr. Chairman, I don't think it's a question so much of keeping the ads off the airwaves. The several states, and there are types of laws where if you do business in this state,
Sure.
you're obviously any jurisdictional laws. If you're going to do business in the state, you are then subject to the law. It doesn't say you can't advertise here. It says if you're going to advertise in a way that's going to advertise in Texas, you are now going to be subject to a law that says you can be liable for injuries caused by the product.
Correct.
And so it's not a question of us mandating that you can't advertise. It's when you're advertising, if you're going to make a decision to advertise, make sure you understand that if the advertisement comes into Texas, you're going to be subject to our laws. I can give you an example in a case that I had, which dealt with the gift cards. And there were states starting to have laws saying gift cards can't expire because you're basically stealing the money from the customer. And California said, I don't care if it's a nationwide card. If it comes into our state and the customer is here in our state, you are now subject to our law on this. And I think that's the nature of this bill. It's not saying that you can or cannot advertise in Texas. It's saying if you do advertisements that come into Texas, you're going to be bound by our law, much the same way with some of our bills that we've had this session on, and we had last session with Mr. Shaheen's bill on internet and child pornography and all that. None of them are done here, but if they come into our state, you're subject to our jurisdiction.
So the difference there, and I was thinking about the same example, the difference there is that we have the ability to geofence when it comes to internet. We have the ability to geofence Texas out of, so there are certain things that you cannot access in the state of Texas, but once you cross over the state line, you can access from Louisiana or Oklahoma by virtue of where you are physically. But if, maybe my point is that at some point I would hope there would be a national answer to this, because I know the FCC controls and has authority to control the airwaves, specifically when it comes to radio and television. But I want to understand, are we, by virtue of this bill passing, are we telling all, maybe we are, maybe that's Representative Luther's intent, is to allow all vaccine manufacturers to tell them you cannot advertise at all on national airwaves?
Well, and one
Or will
thing
that be the effect of the legislation?
A sort of, I don't want to say ancillary, but a similar thing, you'll see ads, particularly for gaming, but for drugs and other things, where across the bottom, there's a whole lot of words. And it's like, in California, it's this, and in Ohio, it's that, and in New Jersey, it's this. And in fact, my brother engages in advertising for pharmaceuticals. And you might take out a full-page ad and have to take out a whole second half page just to put in the disclaimers. So there are already instances where even though your ad is being broadcast or being put in a national magazine back when we had magazines, the fact that you're going to come into our state subjects you to whatever our treatment of that is once it crosses into our state line. And I don't think that the law is really unclear on that. From an interstate commerce standpoint.
Do vaccines come with Surgeon General warnings, any of them?
No. I know.
Well,
no.
None of them do. Even experimental, there's never a Surgeon General warning on for instance, you can take this, but here are the potential risks if you do. There's no warnings whatsoever on vaccine advertising?
From what I understand, no. In fact, providers are not even required to provide informed consent with vaccines.
Okay. Members, any other questions for Dr. Bowden? Yes, Representative LaHood.
And I just wanted to, I think, piggyback on what you're saying. I think you're asking about the Surgeon General's warning, and I'm not an expert, but on reading the bill, I think it has to do with the inability to file a lawsuit. So it's not, I don't think the issue, and maybe it is both. Maybe it's that they're not telling you that there's potential side effects, or maybe it's just, what I read from it was the fact that there is informing people that they are, if something goes wrong, you cannot sue them. Mm-hmm. But I just wanted to clarify, I think, and we'll find out more, but I don't want to overstep myself.
Speaker Moody.
I'm sorry, going back to that, are not statements given to, parents of children or those that are receiving vaccines, vaccine information statements given, those are promulgated by CDC, and those are provided to tell you what this is, what the risks can be. Yeah, it gives you benefits risk. There's like kind of a list of information that's provided for any dose of vaccine that goes out. And if it's for a child, the adult gets it.
My son, my 18-year-old son, got the meningitis shot on Monday. He didn't get any information sheet. And
so you're telling me in no case is this done? We're not handing out information, because every time I go get my child vaccinated, when they were born, and they had all those different things that could be done, that I received all that stuff as the parent in those situations. Here's what it does. Here's what it doesn't do. Here's some health risks that have been reported in some populations. Did that
Well, I'm
I
not
the
sure
outlier
that has
here?
anything to do with the bill, but
No, I know, but you said that these warnings aren't being given to people when this happens. I think that's inaccurate.
well, none of the patients that I spoke to, that were
'Cause the
injured,
chairman's
got
question-
any kind of. They weren't warned that they would have tremors, they would have severe debilitating pain,
Understood.
that they would have really bad fatigue. They weren't warned
Understood,
of any of
understood.
the things that
Hold on,
happened to them.
hold on.
I don't think we're
The
being
question that-
adversarial here.
I'm not trying to be adversarial, but
we're on a fact-finding
the
mission.
chairman asked a question about vaccines in general. I'm saying, like, I am very aware of this stuff going out when vaccines are deployed or when people are receiving them. So I think the statement you made was categorical as to all vaccines. If you're talking about a particular vaccine, I think that's a different conversation, but that's what I wanted to clear up. There's no categorical lack of information when it comes to vaccine, when they offer vaccines to patients.
Well, I think it was a lot, the rules were a lot different for the COVID shots. When my kids were little and they got all their shots, we did get those information sheets. But talking to sort of real life instances, and I've talked to parents where their children were injured, not by the COVID shots, but by other shots. They didn't see any of that coming. The severe injuries that can rarely, but sometimes happen with some of the other vaccines on the market, they were caught off guard. They were told, you're going to get, your child may get fussy and have a fever, and you may need to give them Tylenol. But they weren't aware that the child would, have or even they talk about seizures, but they weren't aware that they have some sort of a permanent neurological issue following the vaccines that they gave their child. And I think the point of this is more, if you're going to widely advertise to the public, why can they not be subjected to the same rules that every other pharmaceutical product is subjected to?
So-
It just seems common sense.
So, Dr. Bowden, just so I understand, so right now, an individual, if they're vaccine injured, cannot sue the vaccine manufacturer, correct?
Correct.
Is that state or federal law?
Federal law.
That's federal law. So this bill, it's my understanding that this bill says that if a vaccine manufacturer advertises in Texas, that it would be liable under state law, that someone could sue them. Is that your understanding of the bill?
Correct.
If there's a vaccine injury, that they could sue if in fact that vaccine manufacturer advertised in the state of Texas. Is that your understanding of the bill?
Yes.
Okay. I think my concern is that, or the reality is, if someone brings a vaccine over state lines from Louisiana into Texas, they're not advertising in Texas, but someone brings a vaccine over and someone receives a vaccine in the state of Texas and is injured, they would not be able to sue, correct, under current law?
Can you clarify that? What do you mean? Somebody brings.
The trigger here, my point is that the trigger of the liability is whether they advertise or not.
Correct.
Not whether there's a real injury or not. It's just whether they advertise. That would be the trigger right now. They're not allowed to sue under federal law, but if they choose to advertise under this bill, they would be allowed to. Trying to understand
Right.
your understanding of the bill.
You're not going to sue unless you have a bad injury, I would think. But
Well,
yeah. And if
Go ahead, Representative Schofield. Well, sorry, Representative Flores and then Representative Schofield.
Yeah, I have two questions. One is, okay, you see these commercials for all of these drugs and not vaccines, but if it were the vaccines, would it be cured if they rattled off all of the, how fast they rattle off all the possible side effects of this and this and this and this and this at the end of every commercial that is, for these drugs? I mean, would that cure that? I mean, if they actually stated those it doesn't say this in this bill, but perhaps that would be one way to, that's how pharmaceutical companies shield themselves, because they rattle off all these things at the end of their advertisements, right? That's what they try to do anyway.
Right. If it were up to me, I would just ban it all from the airwaves to begin with, and I see your point. But it's a start, and it's the fair thing to do, in my opinion. It's not fair just to give special rules for them.
Yeah.
So.
Second question is on causation. They advertise, you get the vaccines, and something happens. I mean, I guess that you have to undergo the entire, issue of causation, whether or not it's linked to that particular vaccine or not. So, I mean, when you go through litigation on, finding causation for any substance that you've been exposed to, you've got to prove the causation. I would imagine there's that same rigorous standard that would need to be followed to prove causation, that to link it to that before anybody could be found liable, correct?
Correct, and I mean, you do that by eliminating all other possibilities and linking it to the timeline and taking a good history. Maybe it can definitely be done. I've definitely seen clear-cut vaccine injury, and prior to COVID, I never had seen that, but yes, now I do unfortunately see it.
Okay, thank you, Representative Schofield.
No, thank you.
Okay, members, other questions for Dr. Bowden? Okay, the chair recognizes Michelle Evans. Michelle, I've got you here on behalf of Texans for Vaccine Choice registered for and yourself registered for the bill. Is that correct?
That is correct.
Okay, go ahead.
All right. Good afternoon, Chairman Leach, committee members. My name is Michelle Evans. I'm the political director for Texans for Vaccine Choice, and I represent myself and TFVC in favor of HB 3441. This legislation would hold vaccine manufacturers accountable for adverse events when they choose to advertise their products directly to the public. It would ensure fairness, transparency, and accountability in a system where pharmaceutical companies profit from marketing while enjoying unique legal protections. Currently, vaccine manufacturers in the U.S. benefit from immunity under the National Childhood Vaccine Injury Act of 1986, shielding them from liability for injuries caused by their products. This protection was enacted to stabilize the vaccine market and encourage production at a time when lawsuits threatened availability. However, the landscape has changed significantly since then, and today these companies are not merely passive suppliers to government programs. They actively advertise their products through sophisticated multimedia campaigns targeting consumers directly and generating substantial profits. When a company chooses to market its product in this way, it assumes a greater responsibility to ensure that its claims are accurate and that the public is fully informed of potential risks. The current system creates an imbalance. Manufacturers can promote their vaccines, often emphasizing benefits while downplaying risks, without facing the same accountability as other products. If the same company markets a painkiller and fails to disclose side effects, it faces liability. This liability exemption undermines consumer trust and leaves injured individuals with limited recourse, relying solely on the Vaccine Injury Compensation Program, otherwise known as Vaccine Court, which is a taxpayer-funded and often criticized for its complexity and narrow scope. Holding manufacturers liable when they advertise would align their incentives with public safety. Companies would have a stronger motivation to conduct rigorous post-market surveillance, disclose risks transparently, and invest in safer products. Advertising inherently shapes public perception, and with that influence comes responsibility. Finally, this is a matter of fairness to those who suffer serious adverse events. The VICP, while well-intentioned, places the burden on injured individuals to navigate a bureaucratic process and on taxpayers to foot the bill. When manufacturers profit from advertising, they should bear the responsibility, not the public. This legislation restores a basic principle. With great power and profit comes great accountability. I urge you to support this bill to protect consumers, promote transparency, and ensure that manufacturers are held to the same standard as other industries when they choose to advertise. Thank you.
Thank you, Ms. Evans. Members, any other questions or any questions for the witness? Yeah, Representative LaHood.
Thank you, Chairman. Ms. Evans, do you have any experience or know anyone that had experience with bringing a claim in vaccine court?
I personally do, and I know many people who do.
Okay. And I'm ignorant. I'm a trial lawyer, but I've never done that. I guess how is that experience different than what I guess a lot of what we're litigating, or not litigating, but what we're debating on bills? How is that different?
That's kind of a complicated answer, but the first thing to keep in mind is that anybody presenting a claim to the Vaccine Injury Compensation Program is up against Department of Justice attorneys who are representing the Department of Health and Human Services, and this is an administrative proceeding. It's not your typical court. So you have an administrative magistrate. I think it's a very small percentage of those who bring claims that are actually, they are compensated. I've known a woman who stood over her daughter in her daughter's hospital bed with an HHS attorney nitpicking the cost of diapers and wipes for a child who is 15 years old and paralyzed from a tainted DTaP vaccine. That child died shortly thereafter. There's just no getting that back. I knew a woman who went through vaccine court for 10 years for her injured son and was ultimately dismissed after traveling the country at her own expense to get experts. And I myself brought a claim from my daughter, and despite mountains of medical records from geneticists, neurologists, immunologists, gastroenterologists, I mean, it ran the gamut. We were summarily dismissed very early in the process.
And I don't know, is the vaccine court, is it in every state? Like, did you do it in Texas? Did you have to fly somewhere? I have no idea.
I had an attorney here in Texas that specialized, part of her practice specialized in vaccine injury claims.
But is the court here in Texas, or is it
No,
somewhere else?
it's in Washington, D.C.
Okay. And I'm sorry what you went through. Without getting to the politics of debating, pro-vaccine, anti-vaccine, regardless. Let me ask you this: your child, were you forced to vaccinate, or you chose to vaccinate?
We chose. She was on a delayed selective schedule. My oldest was on the full schedule initially.
And before you made that choice, did you know that, God forbid, we all know, even Tylenol can have an adverse reaction, but did you know, God forbid, if something happened, that legally you would have no recourse?
No, I did not.
And had you known that, would that have changed your decision?
It would have
Possibly?
informed that decision a little bit more deeply, yeah. I would have understood more about what the true risk would be if something were to happen to her.
Okay, so this is kind of like an informed consent kind of situation.
Yes.
Thank you.
Thank you.
Thank you, Representative. Members, other questions for Ms. Evans? Okay, thank you both for being here.
Thank
Good
you.
testimony. I see that Jackie Schlegel has come in. Jackie, do you want to testify? The chair calls Jackie Schlegel. I've got you here on behalf of yourself and Texans for Medical Freedom testifying for the bill. Is that correct?
That is correct.
All right, go ahead.
Was my name called? Did I miss it?
Yes, but we're
I'm
glad
so-
you're here.
I'm so sorry. I
That's
waited
okay.
all day and then missed.
That's all right.
So,
Go ahead.
Thank you, Chairman Leach. One, for your leadership for medical freedom, protecting parental rights, and prioritizing this bill. I also want to thank Representative Luther for this common sense legislation that you're boldly leading on. I'm very, very grateful for her. The COVID-19 pandemic created extraordinary challenges, forcing quick decisions under emergency conditions. Experimental vaccines were deployed at record speed, accompanied by widespread, highly coordinated advertising campaigns, many of which downplayed risk, overstated benefits, and targeted every demographic from seniors to children. Commercials didn't focus on informed decision-making or medical nuance. They pushed fear. We were emotionally manipulated into believing that saying no to this vaccine was the same as choosing a death sentence. Texans responded. They trusted the message. They trusted the system, but for far too many, that trust was betrayed. Not by their neighbors, not by their doctors, but by pharmaceutical companies that face no consequences for the harm their products cause. This is why this bill is so important. This bill holds manufacturers accountable not for making a vaccine, but for advertising it in Texas and then causing harm to the very people they market it to. If you promote a product aggressively and claim it's safe and it turns out to cause injury, you should not be shielded from liability. That's not controversial, that's common sense. Right now, vaccine manufacturers enjoy sweeping immunity, no matter their harm, no matter how misleading the advertising is. Meanwhile, injured Texans and their families are left to absorb the cost, the medical bills, the lost wages, and the emotional trauma. There's no recourse. There's no justice. I'm going to put my written testimony aside for just a second and speak from the heart as a parent of a child who was injured by her vaccines. I believed what I was told. I did the right things for my child. And I'm not alone in having a child who faces a very uncertain future. We're facing an epidemic of kids we don't have housing for. Just this week, 1 a.m., I'm on the phone with a parent with a 30-year-old in crisis. I deal with this every single week. So as we talk about these bills and we talk about vaccines, just want to encourage you to be very open-minded because we play by the rules. We did what we thought was best for our kids, not realizing there was no safety net. We didn't realize we had a choice. I know these are complex issues. These are really tough subjects, and far too often they're seen black and white. You're anti-vaccine or pro-vaccine or nothing in the middle. That's just not the case for most of us. I welcome any questions, but I really encourage you, the parents, the people who are making these decisions, they want to make the best decision for their children, but they need access to good, solid information, not fear, not advertising on television that, leads them in the wrong direction. They need accurate information. So I welcome your questions.
Thank you. Chairman Dutton.
Thank you. You said you were told that it was safe. Were you told that by the manufacturer or by the doctor?
So the general consensus, really, when I was making these decisions for my children, reading parent magazines, talking about it in the baby play groups, is that these vaccines were safe and effective. Less than 1% of kids would ever be harmed. I didn't realize when I took my daughter in and gave her 9 in one day that combination hadn't been tested in combination
I'm sorry, but
for
I don't
safety.
mean to cut you off, but you said you were told that it was safe, and I was just wondering who told you that.
I read about it.
Oh, you weren't told then?
I was told by my doctor. I read about it in magazines. I watched it on the news. I mean, I think, as a parent, when you have a child and you're preparing for them, that is what you do, and you research all things.
But the doctor is the one who actually told you, and the rest of it you kind of got on your own through reading and whatever else.
In advertisements. Like I said,
Okay.
I mean, I remember very distinctly reading, an article in a magazine and not really having access to full information. And I realize this bill doesn't cover everything that I think we as parents are hoping for medical freedom. But I think the intention of this bill, the conversation that it's starting, I think is absolutely crucial as we look forward to how do we bring accountability back to this system that has completely run amok. There is no accountability whatsoever right now.
All right, thank you, Mr. Chairman.
Thank you, Chairman Dutton. Members, other questions for Ms. Schlegel? All right, thank you, Jackie.
Thank you.
Appreciate you. Does anyone else wish to testify on, for, or against House Bill 3441? Seeing none, the chair recognizes Representative Luther to close on the bill.
Thank you very much, Mr. Chairman and Madam Vice Chair. I want to thank all of you for participating in this conversation and being interested in this topic. I fully vaccinated both of my girls. I am not anti-vax. I fully believe that many of the vaccines we have today have saved countless lives. But the system that we have today is the result of our decision to test a thesis that was made in 1986 when we passed the National Childhood Vaccine Injury Act. And the thesis ultimately was that we could improve health outcomes by eliminating accountability for those outcomes. What a thesis. I'd say, I think we're getting exactly what our system incentivizes, which is efficiency and speed of development. In the case of COVID-19, we rushed a vaccine to market with so little testing that we didn't have a set list of defined injuries for which our injury compensation fund could compensate individuals. Bureaucrats working in the CICP were left to make judgment calls on a case-by-case basis according to a report by the U.S. Government Accountability Office. Those weren't adopted until April of last year. The result of our choice to incentivize speed of development over safety and reliability has been devastating by any metric. Public trust in our medical institutions and medical community is at an all-time low. God forbid we actually experience a similar emergency situation, and maybe we develop a vaccine that works well and is truly safe, but the public won't go for it. And under the current situation we have right now, and public trust aside, real people are getting hurt, and there's no incentive for these manufacturers to insist on their product being safe before taking it to the market. So when we look at the advertisement that's taking place, when we see Pfizer paying for Super Bowl commercials and paying pro football players to act as a vaccine spokesperson and paying them millions of dollars, I understand why. It's an attempt to repair a reputation. But there's no way to circumvent the public's understanding that it is their loved one that is injured, and there's no recourse, and the company responsible will feel no agony over it. In some ways, that vaccines are advertised, especially during COVID, were based on social and emotional pressure rather than providing accurate information to patients. We are begging for truth and transparency from our government for all Texans. Beyond this social pressure, many people were forced to participate in what was essentially a drug trial on the public by being threatened with losing their jobs or being unable to live normal lives if they chose not to get vaccinated. And for those who suffered adverse outcomes, there is generally no recourse. We recognize that the federal government has adopted a stance on manufacturers being held liable for vaccine injury. With this bill, I'm encouraging Texas to lead, and at the very least, expect those who try to convince the public to take a vaccine through advertising, they take accountability. Right now, this bill has 60 co-authors and 3 joint authors, including both Democrats and Republicans. This is a bipartisan issue. Let's take the first step in challenging the existing system we have that is harming public health and confidence of our public health system in so many ways. And to the vaccine manufacturers, if you believe that your vaccine is safe as advertised, I challenge you to put your money where your mouth is. Thank you, members and Mr. Chair. I appreciate your time. I respectfully ask for your favorable report, and I close on the bill.
Thank you, Representative Luther. Representative Flores.
One obvious question, and I'm going to ask it.
Please.
Obviously, this bill would be prospective, not retroactive, correct?
Correct.
I mean, any vaccines taken prior to the effective date of this bill, and so even if you exhibited things 10, 20 years from now because of the COVID or another vaccine that you took prior to the effective date, would not be subject to any of this, correct?
Yes, ma'am, that's correct. It would go when the bill is put in place, then the action would take place, because the only time that they would be liable is if they actually advertised after the fact. And then they would also have to have taken the vaccine after the facts. And we can put that in the bill if that would be helpful.
It's just common sense, but also, how did you decide to wear that color shirt today?
I wanted to match the room.
Okay, great. Great choice. Thank you. Great layout.
Yeah, great layout, Representative Luther, and it's a complicated, complex issue, but it's a very important discussion for us to have, which is one of the reasons I've signed on as a proud joint author of the bill. And it's interesting to me that none of the vaccine manufacturers are here testifying today.
They might
know,
know
and
me,
I
sir.
too. Well, I won't get into my family's what we do with our children and ourselves, but we should respect the widespread disagreement on which vaccines are good, who should take them, which ones they should take. But I don't believe that we should debate on who should decide, and if companies are actively engaging in advertising and marketing here in the state of Texas and causing harm to Texans, they ought to not be able to do so without some sort of responsibility and liability, in my opinion. How that's done, I'm not sure.
We've actually spoken with the FCC and the FTC. I just wasn't up here to answer
Okay.
that question. Their agreement at this time was they think that it could be done, and right now, like what Representative Schofield said, there are commercials that are done nationwide, and they block out a state, and that has been done in the past. We've spoken to ad buyers as well, where they can put the ads where they want to in different regions. So they could actually substitute a different commercial for that one, and it has been done in the past. But we also have a connection with someone at those agencies that we are willing to give to the
Okay.
committee as well.
Okay, I'd encourage you to continue those conversations, keep us posted, and also maybe have some of the vaccine manufacturers themselves in to meet with you. I would like to know if they refuse to do so.
Well, of course they do. They just made $26 billion.
Well, I understand, but the way we work, at least here in this building and with this committee, is if people have a strong position on a bill, then they should be willing to come into the author's office and
Right.
express that position to you. And
I'm
have a
as shocked as
conversation
you
about
are that they're not here. I'm shocked.
it. Chairman Dutton.
I had a question, Mr. Chairman.
Yep.
In a lot of these ads, what you hear is what the vaccine does, and then there'll be a 30-minute worth of disclaimers.
Not on the vaccine ones because they're not liable. You're talking about regular medication or prescription medication?
Well, I'm getting to the point that if the manufacturer advertises and puts in the disclaimers, how does this bill affect that?
So we talked about this a little bit earlier. There is a difference between the way vaccine manufacturers and drug manufacturers are treated.
Right.
There's a special carve-out under federal law for vaccine manufacturers, and that's what this bill is aimed at.
What Representative Mrs. Flores said, that if we put those words in, would that be satisfactory? To me, no, because right now, what are they afraid of? If you're advertising your product as safe, then advertise it. But I bet they stop advertising, sir, and I'm not sad about that.
Right. Well, the other question I had is, suppose the manufacturer advertises through a separate entity.
They're still paying for that, and they would be liable.
So as long as they're paying for the advertisement, they would be caught up in this bill.
Yes, sir.
Okay. And does it say that somewhere, or that's?
The bill is very basic, and what we told Chairman Leach in his office, if there's ways that we can make it clearer, we're willing to do so. The bill just only states advertisement, and so we would actually have to list exactly what that is. We do not want a doctor to not be able to give a pamphlet to their patient and say, here are the vaccines. Like, we don't want to keep anything like that from we obviously don't want that to happen. I'm just talking about TV, magazines, no social media, all of those things where they advertise it and say it's safe and basically bullies people into taking it, but not listing off all of the things, I think is a problem. But they don't do that because they're not liable anyway.
So if they did do that, though, that would take them out of the bill.
I'm sorry, say it again?
If they put in all the disclaimers that I think you just said, would that change their status in terms of this bill?
No, sir.
Okay, so even with the disclaimers, but if they advertise, or if the doctor who gave the pamphlet, would that be considered an advertisement?
No, sir. That's why we need to specify what advertise means. It's not what your conversation with your doctor, and we're not promoting not to get a vaccine. We just want a more informed decision, and we don't want celebrities on commercials basically making people feel like lesser than if they don't take the vaccine.
I understand that, but I was just curious as to whether or not this would cause manufacturers to simply rely on doctors doing the advertising.
I hope so.
And so that
Or
would,
they feel like their drug is safe. There are several vaccines. There were, I think, 8 vaccines that were suggested when I was a child. I got like 8 vaccines, and I'm still alive. It's crazy. Right now, it's like 84 doses for a child from birth to 18 years old. It's ridiculous. I think that if they were liable, I don't think they would just add their shot to the list and get all the money because the doctors are recommending them. The doctors are also not liable for vaccines.
When would, and this is something Representative Schofield and I just talked about, when would the injury occur? At the time of the shot the vaccine was received? Or at the time you suffered some injury from the vaccine?
Mm-hmm. That is determined by a doctor, and they would have to prove that in court. So they would have usually and to be frank with you, getting these signatures on this bill, I've run into 5 House members that have direct connection with vaccine injuries, either themselves or a family member. And what they said was as soon as they got the vaccine, within a few days, it was a very horrible circumstance that led to heart surgeries, autism, and if someone going perfectly normal to something very bad, and the only chance it could be was the vaccine. They would have to prove that in a court of law, of course.
Well, I was wondering that because there would be a statute of limitations involved, depending on, and where do you start that?
I think that we have to. I think we can talk to doctors and see what a statute of limitations could be. But usually with vaccines, and I'm not a doctor nor an attorney, but I would say that the reaction is pretty quick after getting the vaccine.
So you would contemplate it being somewhere close to the time you got the inoculation?
Somewhere close to that, yes, sir. Within weeks, probably.
That would be the start of the.
Yes, sir.
Start of the clock in terms of statute of limitations.
Yes, sir.
All right, thank you, Madam Chair.
Thank you. Rep. Flores?
Yeah, at the very least, a definition of the term advertisement, like you said, advertising either over the airways or in print, and peg it to the manufacturer if you don't intend to ensnare doctors into the web of liability.
I
So
do not.
that would be something that just reading this bill, it would be important to have so that people can understand what it is.
Yes, ma'am. I'll take any type of anything that you would like to add or that would make the bill better and tighter. I'm open for suggestions, and I appreciate that. Thank you.
Thank you. Thank you. If there's no objection, House Bill 3441 will be left pending. Hearing no objection, we will leave House Bill 3441 pending.
Thank you so much.
Is that your first?
Yes.
Congratulations.
No hazing? That was the hazing? Come on, guys. Oh, no. It's good. Oh.
Thank you. The chair recognizes Speaker Pro Tem Moody to lay out House Bill 3704. Excuse me. The chair lays out House Bill 3704 and recognizes Speaker Pro Tem Moody on behalf of Chairman Anchia to explain the bill. We do have a committee substitute. Do you want to take up the substitute? Yes, please. Okay, thank you. The chair offers up a committee substitute to House Bill 3704. The chair recognizes Speaker Pro Tem Moody to explain the substitute.
Madam Chair, do you mind if I present from up here?
No problem.
Okay. I do want to thank my colleagues on the committee for asking questions on the last bill, which gave me an opportunity to read this great bill by Chairman Anchia. Actually, this is an issue that you all are probably aware of. We're talking about deed fraud, right? This is something that's probably in all of your counties where Texans have been victims of their land and homes being stolen by deed fraud. So, person forging an owner's signature, or and then filing the fraudulent deed. These are also transactions that are going to take place out of the title, kind of the title arena. So the notaries public are the ones that become the barrier between this fraud being perpetrated, and they're the ones that are the firmest barrier for the fraud being perpetrated. So that's really the only time you can have a check on authenticity. So that's what this bill aims to do, is to strengthen support systems around notaries public, also to maintain their records for longer, some training that's going to be developed by the Secretary of State. This was a product of a lot of research. Committee on Business and Industry actually did an interim study on deed fraud as a topic. So a lot of these ideas came from that conversation. There's a new criminal penalty that's developed when the person signing a document is not present. So that's when two different classes of offenses created there. A third-degree felony, if the property, I believe, is the home, and then a Class A. Let me make sure I have this right. Yes, documents affecting real estate, it would be a third-degree felony. For anything else, a Class A misdemeanor. So I think kind of right-sizing the penalties depending on the type of fraud that's occurring. The substitute essentially made a couple of changes that were at the suggestion of the Secretary of State's office. One of them ensured that an offense under the bill included quitclaim deeds, which is a form of property transfer and instances where people put up property as collateral for loans. And there's also a change that capped the maximum amount of education the notary is required to receive to 2 years, or 2 hours, I'm sorry, and that would ensure the Secretary of State is the only entity that establishes or offers the educational course so that it's uniform throughout the state. Those are the high points of this legislation. I do think there are witnesses here to talk about it. I'm happy to try to answer any questions on it, and I want to thank Chairman Anchia's staff for going over everything with me. So happy to answer any questions. If not, I assume there's some witnesses, and if you'd recognize me to close when the witnesses are done, I'd appreciate that.
Thank you. Members, are there any questions for Speaker Pro Tem Moody? Okay, we do have a number of witnesses, and we will reserve your right to close. We'll do this in panel form again. Allen Place, Texas Land Title Association 4. Jennifer Fogg for herself and the County and District Clerks Association of Texas, also 4. And Philip Clark with the Dallas Criminal District Attorney's Office from John Crusoe's office, and 4. Thank you all. Mr. Place, again, show you with Texas Land Title Association. You are for the bill, and we're ready when you are.
That's great. Thank you, Madam Vice Chair. On behalf of Texas Land Title Association, we do support the legislation by Representative Anchia. Many of our members, of course, are notaries as well, and they understand the new compliance requirements, and we're certainly fine with that. Our members are the most likely people to be in the room when you're buying or selling a house, when potentially some of the things that Speaker Pro Tem Moody talked about. But our people are dealing every day with a variety of types of fraud, wire fraud, mortgage fraud, you name it. And this is not new, but there seems to be, with probably rising property values, you see more of what this bill attempts to prevent. And so certainly it's not lost on us that there's fraud in the transaction. And certainly we understand that when there is fraud in a title transaction, title doesn't necessarily transfer, but at the very least, it's inconvenient and unsettling to the homeowner that, you know, goes to the clerk's office or gets a call and you know, finds out that your house has been attempted to have been sold, kind of thing, which is sort of a shock if you didn't really do that transaction. So we're in support of the bill and be glad to take any questions.
Thank you so much. Jennifer Fogg, here for yourself and the County and District Clerks Association of Texas, and you are for the bill, correct?
Madam Chair, that's
Great.
correct. Madam Chair, committee members, I'm Jennifer Fogg, and I'm the Rockwell County Clerk. And to reiterate, I am here on behalf of County and District Clerks Association of Texas. I'm a big proponent of property fraud because, well, preventing property fraud, I'm sorry. So yeah, big difference. I feel like this bill being passed would be the least aggressive nature to try to protect our citizens in the great state of Texas as well as the notaries. So many professionals are required to have continuing education and are required to have education whenever they take office, such as myself. IT professionals are required to have continuing education. I'm required to have paternity testing, affidavit of paternity training and CJIS training, and numerous conferences that we attend. We get like 20 hours minimum a year for attending conferences and getting education. And so I feel like, again, this is the least aggressive approach to deter any bad actors from committing fraud. And we do have cases that we could refer to that also include notary fraud in Dallas County, but I would defer to Philip Clark for that, and I close.
Thank you. And Mr. Philip Clark, Dallas Criminal District Attorney's Office, John Crusoe's office, and you're for the bill, correct?
Yes, that's correct. Thank you, Madam Chair. Thank you, Representative Moody, and I want to thank Representative Anchia for bringing the bill as well. I am for the bill. This bill is essentially about the security of the property records in the state of Texas. I prosecute the cases of deed fraud throughout Dallas County, or real property theft. And if it's news to you that this is happening, I just want to tell you briefly, it's actually pretty mind-boggling. Not only that a fraudulent signature can be used to convey title to, or attempt to convey title to property, but that it happens easily. The offense, in a slightly indirect argument that I would make, the offense over here happens very easily because of the action over here by a notary. We all know what a notary public does, and we all know that the function that a notary public serves to authenticate a signature on a document, because the county clerk's office cannot possibly authenticate every document that's come to it. We rely on a notary public. When that happens with real property, as we are discussing here, as you can imagine, the results are devastating for homeowners. Not just for homeowners, also for somebody who then goes on to buy the property from the fraudster. And then they may go on and sell it to another person. And it goes on and on. And we have a long, very interwoven web of lawsuits and distress. And it creates problems for the courts, problems for the records, for the county and for the state, problems for homeowners and buyers. I've seen over 300 real property cases in my time that I've been dealing with these cases. And I can tell you that the process that it takes for a victim to extricate themselves out of this is very lengthy and distressing and often difficult. Many of these cases, not all, but many of these cases involve properties that are, we will say, abandoned or even depressed. Many of these cases, again, not all, but many of these cases involve homeowners who have different levels of sophistication on how to proceed and what to do to protect themselves, their home, their rights, their legacy, their interest. This bill seeks to put a plug in probably the biggest hole in this dam. This bill seeks to strengthen the notary public component of all of these transactions that are occurring. First, by providing education, because if you didn't know, notary public licensing does not have any mandatory education. First, by providing education so that they actually know more of what to look for, best practices, know what the laws are, what's required. Also, putting a notary public on notice that if they knowingly authenticate a signature for somebody that they know is not in front of them, then that is going to subject them to a criminal offense. Also, extending the length of time that they must keep their records. The reason for this is because investigations into these kinds of cases can take a long time. The records retention for notaries is rather short. This would extend it to 10 years, which would match the statute of limitations on many of the kinds of offenses that could be brought. All of these work together to, again, put a big plug in a really big hole in the dam. And with those points before you in this bill, I hope for your favorable consideration, and I am available to answer any questions that you may have.
Thank you. Representative Schofield.
Mr. Place, you testified that you have notaries amongst your members of the Texas Land Title Association.
Sure.
And you're here testifying for the bill, so your members understand that under the current law, they're supposed to already be actually witnessing the signature that they notarize.
Absolutely, yes, sir.
So the notaries that are acting in good faith aren't going to be subject to this criminal penalty because they're not going to notarize signatures they haven't seen.
That's absolutely correct.
Thank you.
If I may, it's important to note that many of the crimes that I'm seeing, not all, most did not go through a title company. And in fact, I see evidence that people are actively trying to move the transaction away from a title company or any other kind of oversight or these checks that we have in place through title companies. So it's important to note too that these transactions are happening there. This is not intended for the well-meaning, well-intentioned, well-trained notary. This is intended for exactly the opposite.
Chairman Dunn.
Thank you. Is most of the problem that we're having with notaries related to property?
I am aware of the problems as they relate to property because that's what's coming through in the criminal cases at the DA's office. I cannot answer the question of whether we have similar issues in other areas, but I would venture to say it's possible. But
Because
where I see it is in the criminal.
This bill extends far beyond the property
Okay,
part of
I'm
it.
sorry.
The bill doesn't limit itself to just property problems. And in the 300 cases you said you were involved in, were they problems with the notary?
Yes, probably 3/4 of them had a problem with the notary, the notarization. Either the notary was duped or the notary improperly notarized a signature without the person in front of them, or the notarization was copy and pasted. That last scenario is not really addressed by this bill because that's someone else taking a document and copying and pasting. But those first two categories, a notary who's duped, education is to help them. Or a notary who is improperly authenticating a document without the person in front of them, the new criminal offense is to help them. And you're right, it's not just about real property, it is about other
Right.
items as well.
But the law now requires the notary not to be duped, as you call it, and not to do things that would permit the fraud to occur in the first place, right?
Does the law require?
The law now requires the notary to be absent of anything related to fraud, right?
Yes,
Okay.
the administrative rules regarding.
Right.
Yes.
And it also has some things in there about being personally witnessing the signature.
Self-dealing.
Yeah, and self-dealing, and so that's already in the law.
In the administrative rules regarding the conduct of a notary, yes.
Okay.
And this is addressing those same rules.
Well, now we're adding more rules to it, and the presumption is that that would cause the notaries to be different than they are under the rules we have right now.
Honestly, that's the hope. Some of these rules have been deemed necessary steps to take, and as County Clerk Fogg mentioned, it's rather tailored, and the least I forget your word, offensive way to do it. It's very on point and seeks to address specific issues.
And have you read the bill?
Yes.
Okay. On page 4 of the bill, do you have it there in front of you?
Thank you.
On page 4 of the bill. You have it, page 4?
I'm on page 4, yes.
Okay. And subsection 4 says, may not require a person appointed as a notary public before September 1st to complete education requirements required for initial appointment as a notary on or after that date. Tell me what that means.
I believe we're working from a different.
The substitute.
And
Oh, you don't have the substitute? Yeah. And of course, the way I was reading that, I wondered whether or not that was grandfathering the current notaries in as far as the,
I also just cannot hear you.
The language you would have would be on the bottom of page 3, the last sentence. It's part of subsection D gets broken out in the committee. Do you have the committee sub of the bill?
I believe this is the committee sub.
okay, well,
Yes.
well, page 4, if you'll turn to page 4.
Yes,
Okay, subsection 4 down there.
yes.
I'm trying to figure out what that means.
This is to say the education requirements are applied in two instances. If you're newly licensed, there's an education requirement. If you are renewing your license, the same education requirement. Subsection 4 is to say if you are currently a notary, you're not required to take the education course now. You're required to take it when you renew your license. So this is to say it's not a requirement for every notary who exists in the state currently until they come up for renewal.
And how long generally are those renewals?
I'm sorry?
How long are the renewal periods?
4-year periods.
And so everybody who, okay. And so you grandfather in the people who are
That's right.
currently licensed and
But not in perpetuity,
only until the
your
time
next
they-
renewal.
And the other thing I wondered about is that it says you can do online.
Yes.
You can do it online.
There are online notarizations.
Right, but you can't do online now, can you?
Notarizations?
Yes.
Yes.
You can do online?
Yes.
And
There-
what effect does that have on the fraud and the problems we've had?
Well, the bill specifically is addressing in-person notarizations. And as far as, does that impact the criminal cases that I see? Absolutely, yes.
Online does.
99 or 100% of them were in person.
Oh, in person, not online.
Correct.
Okay, because on page 3 of the sub, it seems to create an online notarization process.
That's right. It doesn't create the online notarization. It's just saying that if a notarization is pursuant to the rules for an online notarization, right, then this is a definition for what constitutes personal appearance.
And since the notary is required to keep records for 10 years, what would they keep for an online notarization?
My understanding is, it's actually rather a lot. My understanding is that there's a video imaging that takes place with an online notarization. It's via an application, a platform like a Zoom. And then the transfer to show the identification documents from the person signing to the notary. And my understanding is that they also have the ability to, in that moment, because they're already doing, this is a digital thing, they're able to verify that identification
And
in
that's
that moment.
what they would keep. That's what you're saying they needed to keep for 10 years.
The digital files, yes. This is effectively an online logbook.
Okay. For 10 years.
Yes. Currently, it's either 2 or 3.
And their term's only
That's-
4 years.
Currently, it's either 2 or 3, and I'll tell you, already it's a problem with people maintaining and keeping them. By actually, because, and thank you for asking, because there's another element of the bill which adds failure to maintain records as an explicit basis to either suspend or revoke a notary's license. And currently, that is not an explicit basis.
But as my good friend here points out, we're licensing them up to 4 years, but they got to keep the records for 10 years.
Yes.
And you got to keep it, I'm not too computer literate, but, so you got to keep this on your computer or something for 10 years?
I believe that there's a mechanism for that I don't know myself as far as how the notarization happens. But I would suggest to say that if someone were to fraudulently sign over your home to themselves, you may not find out about it for years and years. And it may not be something that you could possibly act on for years and years. And so that's why we're trying to extend the period of time that this could be available to investigators. If in fact you discovered it, you reported it to the police, they wanted to investigate it, this is a very important piece of evidence in the whole process of the fraudulent transaction that happened. And to allow it to dissipate with a short records retention rule that's currently in place for notaries really makes it very difficult to investigate and prosecute that crime that has occurred against you.
And have you found that to be the case in the 300 cases you had?
Many of them, yes. Yes, our investigators are stymied left and right with logbooks, incidents that happened beyond the records retention period, as well as logbooks that are lost.
And what happens in that case?
Sometimes the investigation stops. Sometimes they have other means to go forward. But that is a critical piece of information and evidence in an eventual case.
And what worries me is as often as we, for example, in my office, we keep changing computers and computer systems and the like, it seems like every week we're having to learn something different about computers and the systems we have. And I'm just wondering if we don't do something that prescribes how you maintain the online notarization process.
I believe there is. It's not going to be contemplated by this bill, but I believe that the online notarization rules do cover the retention methods. This would just extend the retention period.
Where would it do that?
That would be in the same, I believe, Chapter 400 of the Government Code. And I believe that there is another witness who's going to be able to be more specific on that. And if not, we will work to get the specific information to you.
Chapter 400, you said?
Of the Government Code.
And that covers the online notarization process?
I believe so. Again, I would have to get the specifics to you if we find that that's not completely accurate.
Oh, so that may not be accurate.
The online notarization part is something that I'm not prepared to speak to directly today.
Okay. All right. Thank you, Madam Chair.
Thank you, Chairman. Representative Flores.
So going back to the offense of a Class A misdemeanor and possibly jail time if it involves real estate, is there any other liability to the notary if there is a fraudulent sale? And, I mean, is this considered, something that they could be, found liable for in other ways for a fraudulent transfer of property?
My understanding, and I think there will be some notary witnesses perhaps,
Oh,
but my
okay.
understanding is that there is a bond that is required for every notary. It is a $10,000 bond, but there is a bond that is required for every notary, and that is something that an aggrieved person could pursue.
So they could
But
be
it is limited to $10,000.
sued for up to $10,000 and plus jail time if they're caught having done this, all that, possibly.
The jail time would relate to
A real estate transaction.
when you know that they're not in front of you.
Yes.
And the jail time is applicable with a misdemeanor as well, but it's increased as for real estate, for real property transactions, it's a higher level offense. But there is jail time available in misdemeanors.
Oh, well, it says here that it's under B on page 2, that it's a Class A misdemeanor. Oh, except that it is jail felony. It's a jail felony. I'm
It's
sorry.
called a
I
state
misread
jail
that.
felony, yes.
I misread it. Okay, thank you.
Yes.
Thank you. Members, thank you again for your time and your testimony. The chair calls Annette Donker and Kathy Green.
May I address? Ms. Donker is not able to make it.
Okay, thank you very much. Appreciate it. So we had Annette Donker registered as herself for the bill. It's not available. We now have Kathy Green. Ms. Green, you are with AARP Texas, and you are registered for the bill. Is that correct?
Yes.
Thank you. You may proceed.
Thank you, Vice Chair Johnson and members of the committee. My name is Kathy Green, and I'm the Director of State and Federal Strategy for AARP Texas. And on behalf of our 2.5 million members across the state, I am speaking in support of House Bill 3704 by Chairman Anchia. Although AARP Texas works on many issues, our overarching lens on most public policy is determining what is best for the consumer. HB 3704 is related to the education, training, and practices of notaries, but at the end of the day, it is a consumer protection bill, and that is why we support it. You've heard a lot about the definitions of the bill and what it covers. I'm here to talk a little bit about the human impact. This bill is particularly important as it addresses the rising incidence of deed fraud. This is an issue we have heard about from members, as older adults are often targeted because they have more equity in their home, they may own more than one home, and they have circumstances where they are not living in their home, such as when they're living in a long-term care facility. AARP Texas is concerned about fraud losses, as they can have significant impact on the financial security of older Texans. And as they are often retired and no longer earning income, it is harder for them to recover financially. By the way, I invite you to listen to AARP's The Perfect Scam podcast while you are working out or commuting back and forth to your district. The cards I passed out actually linked to an episode on deed fraud. So this is a podcast that we talk about all kinds of scams that affect everybody, not just older adults, but we have lots of stories, and there's several episodes on deed fraud, and this one in particular. So I thought that would be of interest to y'all. We appreciate Chairman Anchia's dedication to fighting fraud and creating strong consumer protections like those in House Bill 3704. And I'd be happy to answer any questions. Thank you.
Thank you, Ms. Green. Members, any questions for the witness? Okay, thank you for your testimony.
Thank you.
Appreciate you being here. Does anyone else wish to testify on, for, or against House Bill 3704? Seeing none, the chair recognizes Chairman Anchia to close on his bill. Welcome, glad you're here.
Thank you, Mr. Chairman and members of the committee. Thank you to Speaker Moody for laying out the bill. Thanks for all of the witnesses that did the heavy lifting. I stand ready to answer any final questions on the bill. And if not, Mr. Chairman, I close.
Okay, thank you. Thank you, Chairman. Wait real quick so your staffer can get a picture. Did you get one? Okay.
Yeah,
Okay,
we're just going to say I was here the whole time.
She's for sure. I can write the post for you. But right when you were closing, she was taking a picture, so I wanted to give her a chance. Members, any questions for the bill's author?
I just have one.
Yes, Speaker Moody.
Can I be a JA on this one?
Thank you, Speaker Moody. I would be honored. Thank you.
All right,
Thanks,
thank you,
everyone.
Chairman. The chair will withdraw the committee substitute to House Bill 3704 and leave House Bill 3704 pending at this time. Okay. The chair lays out House Bill 4101 by Vice Chair Hayes and recognizes Vice Chair Hayes to explain the bill. And you can do so from there.
Thank you, Mr. Chairman, committee members. The number of lawsuits against funeral homes has skyrocketed in recent years following the Texas Supreme Court's decision in SCI Texas Funeral Services versus Nelson in 2018. Prior to Nelson, Texas courts had held that a plaintiff suing a funeral home had to prove there was a contract between them to establish a special relationship and cover damages for mental anguish caused by the mishandling of a deceased human body. In sum, Nelson established that the legal basis for next of kin to sue for mental anguish arises from a quasi-property right in the decedent's body, and a contractual relationship between the parties is not necessary for recovery. This decision has spawned a dramatic rise in lawsuits against funeral homes. Relatives of deceased persons are now pursuing mental anguish lawsuits that extend beyond just the mishandling of remains to other alleged causes of action of emotional trauma related to funeral services generally, including like playing the wrong music or delay in the service or there were not enough chairs. Recent Texas cases have resulted in substantial mental anguish awards against funeral service providers, including a January 2025 jury verdict over $1 million to siblings whose mother's remains were destroyed at a San Antonio burial park, and an $8 million award to parents whose daughter's body disappeared from the nursing home. The increase in litigation has reduced the number of insurers willing to cover funeral homes, making it especially difficult for smaller operators to obtain insurance. Family-owned funeral homes across Texas are either operating without insurance or finding that the cost of the insurance is making it difficult to remain in business. I have a lot more I could say, but I think generally you get the drift. This does not affect all lawsuits for alleged deceptive acts or practices related to the products or services provided by a funeral home or personal injuries caused to persons by the negligence of funeral homes or their employees. Thank you, Mr. Chairman. I believe there are some witnesses, so I'll yield for witness
Okay.
testimony and reserve my right to close.
Thank you, Vice Chair Hayes. Members, any questions for the bill's author? All right, seeing none, let's bring up a couple panels of witnesses here. The chair calls Lee Parsley, Tim Baker, and John Stephen. Hello, gentlemen. Mr. Stephen, let's start with you if we can. Mr. Stephen, okay. I've got you here, John Stephen, on behalf of the Texas Cemeteries and Crematories Association, registered for the bill. Is that correct?
That is correct,
Okay,
Chairman.
go ahead.
Okay. Yeah, our organization represents over 200 cemeteries across the state of Texas. Some of those operations are combo operations, although cemeteries and funeral homes are separate. They may have common ownership of those. And so we're just generally concerned whenever you look at the rise in the litigation, and which it also impacts insurance costs and viability of businesses, that if there's not some kind of action to help curtail these types of claims, that it may force smaller operations to go out of business and leave rural counties and potentially without any type of funeral home coverage. And that's all I have, Your Honor, or Chairman,
Okay.
sorry.
All right, thank you, Mr. Stephen. Members, any questions for the witness? Yeah, Representative Schofield.
I'm just trying to figure out the scope of the bill. We're not talking about lawsuits involving like dropping the body or doing, we're talking about, as I understand it, like I didn't get the orchids that I was supposed to get in my service, so therefore I'm suing for mental anguish. Is that the kind of lawsuit we're talking about?
Correct. I mean, yes.
So explain to me kind of the types of, because when people think of lawsuits involving the funeral director and the service, they're thinking of, they drop my grandmother, or I go to look at my grandmother in the casket and it's not her, it's somebody else. You're not talking about those kind of suits, are you? What kind of suits are you talking about?
Well, I would be, like you were mentioning with the flowers, or maybe even if you have, you have a visitation, maybe with an open casket. I mean, you have to have particular lighting in order to properly show the body, again, because the person's deceased, and to show proper color. And so maybe one of those bulbs burned out and it just doesn't look correctly. I mean, it may have happened, during the service or something. And that, just so there's, you've got a family that's already grieving, you've got a loss, and sometimes whenever you look at mental anguish, sometimes you may have some of those little things that it's hard to tell, is that really just part of, are they grieving, and so they have some of these mental anguish damages versus something that would be completely separate. I guess above that, sometimes it's hard to tell exactly how that would come out. And I mean, in the funeral home business and also the cemetery business, I mean, they're regulated by the funeral commission and also by the perpetual care cemeteries, regulated by the Texas Department of Banking. So there would also be some oversights to make sure that they are complying with certain regulations and rules. And so, kind of to your point, it would just be that you have some kind of misstep, such as the flowers or some other item, that you don't want that to go to turn into one of these $1 or $8 million lawsuits, just because of, they may get sympathetic because of the situation that it's in versus maybe the actual harm that may have been caused.
Can you think of a couple of them? Do you have a couple of examples for us?
Personally, I do not. I know.
Maybe Mr. Stephen does.
No, I'm Mr. Stephen.
Oh, you're Mr. Stephen, I'm sorry.
That's okay.
So you're Mr. Baker?
Yes, sir.
Okay, well, you haven't testified yet, but be thinking.
Yes, sir. Yeah.
Okay, sorry, Mr. Stephen.
No, that's okay. Thanks.
Yes, Representative Flores.
I'm sorry, I walked in a little bit late, so I apologize. But are you saying that we're trying to prevent lawsuits for people that are suing because you put the wrong flowers on the casket? I mean, this is not what I read in the bill.
Yeah, no, you could still sue. It's just a matter of, you've got breach of contract versus mental anguish. This bill would cover mental anguish.
Yeah, but I think
damages.
this is in egregious cases, isn't it? I mean, from what I read in the bill, I mean, it's for and then you're trying to cap damages for mental anguish on cases where there's some serious issues that have occurred, like having the wrong body, or, maybe the embalmment wasn't correct and something happened to the body, things like that. I mean, isn't that, that's what I thought this was that you were trying to do, and that you were providing guidelines for.
I mean, just for one particular part, I mean, you would still have other claims potentially.
Well,
This is merely just for.
other claims in small claims court or something perhaps.
Representative Flores, let's
I'm
hear
sorry.
the other,
Okay.
some of the other
Yeah.
testimony. No, these are legitimate, valid, good questions, but let me go on to the other two witnesses, and then we'll see if we can
Okay.
put some more
Thank
meat
you.
on the bone.
Sorry.
No, you're fine. Members, are there any other questions for Mr. Stephen? Mr. Stephen, we may come back to you, so sit tight. The chair calls, Tim, let's go to you, and then we'll go to Lee Parsley. The chair calls Tim Baker, representing Carnes Funeral Home, and yourself registered for the bill. Is that correct?
Yes, sir.
Okay, go ahead.
Thank you, Chairman Leach, committee members.
Can you
for
pull
your-
that microphone closer to your mouth? Thank you.
Thank you, Chairman Leach and committee members for your time. I'm a 15-year licensed funeral director. I'm the executive director for Carnes Funeral Home. Carnes Funeral Home has been in business for 21 years as an independent-owned funeral home. I am in support of this bill. Tort reform for the funeral industry is truly critical. The vast majority of funeral homes, over 70% still, are independently owned funeral homes. The majority of those independent funeral homes are really one lawsuit away from not existing. Those of us in the industry are compassionate, caring, professional individuals. We provide services for families in their greatest time of need. The funeral homes not only provide that, but are an integral part of these communities. They participate in civic organizations in these communities. They're a vital part of a lot of the activities in terms of funding things for the communities. Some of these independent funeral homes do not have insurance and are literally one lawsuit away from not existing. The majority of the lawsuits in the funeral industry are a result of really three different areas or buckets. There's conflicts between family members, and the funeral home is caught in the middle of it. Family members, and it may not even be the legal next of kin, it may just be a close family friend, they do not like the look of their deceased loved one. Nothing negligent may have occurred, most of the time didn't occur, but they did not care for the presentation. That's a very subjective context, and that leads to a lot of lawsuits. The third area that we find lawsuits in the funeral industry, which when a funeral home or mortuary service is providing services to a municipality, a county, a state organization, or maybe a federal organization. Things may happen, something may occur in those services being provided. The family can't sue the governmental entity. They are going to sue the funeral home. Okay? And if you'll allow me, we're asking for example, I'll provide
Okay, give us one example.
an example of that. We provide services and have for several years for the Texas Department of Criminal Justice. An individual died, an offender died in their care. Personnel of Texas Department of Criminal Justice in error notified the wrong family that their loved one had passed away. Oh, gosh. This particular family chose to transport their loved one to another funeral home I believe it was in the Valley. This was a few years ago. We assisted, being the provider for Texas Department of Criminal Justice in that process, helped them transport their loved one to, and the family members that came, I need to back up, the family members that came and identified their loved one, upon taking them into care, said, yes, this is our loved one. We received the loved one at the hands of the Texas Department of Criminal Justice. Went to the funeral home in the Valley. the mother came in, other family members came in and said, that is not our loved one. Lo and behold, it turned out that was not their loved one. There had been 2 offenders in the system at that time with the same first name, last name. There was a mix-up. The wrong family was notified.
When did this
The
happen?
family,
When did this happen?
This happened in, you forgive me if I have it wrong, I think it was 2013, 2014,
Okay.
sir.
All right, go ahead.
And the family misidentified?
Go ahead.
So the family, they were not able to pursue any actions with the Texas Department of Criminal Justice. They pursued it with their vendor, which was Carnes Funeral Home. That lawsuit started at $1.5 million. So as the funeral home, we did nothing wrong but assist that family in the manner we thought was the best for them. But at the end of the day, we felt the full burden of the liability for that particular mistake. So I provide that as an example of
So that,
a lawsuit
so the family, sorry, I'm just now learning of this. It's quite shocking, actually. Which family ended up suing you?
the family that was notified that their loved one had passed and had not, was still living, and an offender in the Texas Department of Criminal Justice.
They went and an attorney took that case and sued you.
Yes, sir.
What claims did they assert?
Negligence, mental anguish.
I understand.
Is that the same family that identified him as their family member?
Yes, ma'am. It was different family members that identified them at the point of taking their loved one into their care, which was at the University of Texas Medical Branch, if I remember correct. The TDCJ has a hospital called Hospital of Galveston. And they took them into their care with our assistance from that facility. But there were other family members, mom and other family members, once the deceased was provided to the funeral home in the valley, that said that is not our loved one.
Wow.
That seems.
Okay.
So-
Can you go ahead and wrap up your testimony?
Yes.
Thank you. It's very helpful, but go ahead and
Yes.
wrap up.
There are, let me expound upon that a little bit. There are many services that funeral homes and mortuaries provide to these governmental and other entities that are vital to the functioning of our society. That can be transportation, it can be providing cremation to those entities. It even goes into the anatomical world in terms of providing cremation and.
Can I stop you? I got to
Yes.
ask a question. The
Permission to sue the state.
if cremation, did that body end up being cremated or buried? Do you know?
Once the correct family was notified, we ended up taking that deceased back into our care, and that family chose to bury their loved one.
So you would not have proceeded, is there a law in place that prevents you from proceeding with the cremation until the body is identified?
Correct.
Do you get where I'm going with this?
Yes, I can't truthfully speak to if there is a law on the books. The family needs to positively identify, as a general rule, their loved one, and they would sign a cremation authorization authorizing that cremation to
We
move
might
forward.
we might be veering off a little bit here, but I just am especially interested in this. When TDCJ, you contract with TDCJ.
Yes, sir.
Correct?
Maybe they did a
Yes, sir.
And so, how many
Jailbreak.
funerals or burials do you do a year for TDCJ?
Well, the number of cases it'll vary from year to year, 550 to 600, sir, through that entity.
And who is responsible, which party is responsible for the identification of the body that is in your custody?
That comes to us, the initial responsibility of that lies with the Texas Department of Criminal Justice. They identify that deceased to us. They make that call to us, that this offender has passed, and provide all the vitals on that offender to us. Then, if there's next of kin listed in what's called their travel card, the next of kin is appropriately identified that their loved one has passed.
So by you or by TDCJ?
By TDCJ.
Okay, go ahead.
So these other services that funeral homes and mortuaries provide to these other entities come with very little, let's say, compensation for the business, being the funeral home or the mortuary, but all of the liability lies with the funeral home. And it is I'm just gonna say an unfair liability.
What do you get paid for by TDCJ? How does that contract work?
Depends on the disposition chosen. If the decedent, the family decides, or if there is no family and they stay as a ward of the state, TDCJ will provide for a small service and a burial in a state cemetery. I don't know the exact number. That might be $1,500 to us as the contractor. They also have the option of family can claim their loved one, and if they do, then the state, as Texas Department of Criminal Justice, steps out of that financial responsibility, and all of that responsibility then goes to the family financially.
Okay. Wow. Okay, members, any questions for the witness? Yeah, Representative Flores.
Full disclosure, my family owned a funeral home, and I was
Yes,
a
ma'am.
shareholder in one. We sold it since, but, so, understand the business and the great care that goes in by both my brother-in-law before he passed away, and then my sister as the director. So, you know, all due respect, I totally understand, but my reading of the bill was that first of all, I should have said, you should have asked for permission to sue the state from the legislature to recoup the amount of money that you got for indemnification or whatever, because there is a mechanism for that, and it's not often granted, but it is, especially in an egregious case like this. I would hope that the state would step up for its responsibility and allow, you know, somebody to sue to recover whatever, you know, damages they were forced to pay on behalf of the state's mistake. But anyway, I'll just leave it at that. But I'll just let the other witnesses testify and ask those other questions.
Yes, ma'am.
Members, other questions for the witness? All right. Chair calls Lee Parsley. Lee here on behalf of Texans for Lawsuit Reform, registered for the bill.
That's correct.
All right,
Thank you.
go ahead.
Chairman Leach, members of the committee, Lee Parsley for TLR. I want to talk really about what the bill is about to try to help some with that, and so that we're all kind of on the same page about that. Representative Schofield, Representative Flores have both really asked about that. So what the Supreme Court, as Representative Hayes said when he laid out the bill, the Supreme Court handed down a decision a few years ago that said anyone with a special relationship with the deceased can have a lawsuit for mental anguish. It really doesn't say negligence in it. It just says your lawsuit's for mental anguish relating to the mishandling of the body. So it's supposed to be related to the mishandling of the body. But I think what you're kind of hearing here to begin with is the concept of mishandling the body has come around to be, I'm not happy about the flowers. So that's part of what they're worried about, is the mishandling the body has now become all kinds of things. People plead all kinds of stuff related to that's allegedly mishandling the body. So that's number one. And then, of course, the special relationship potentially is kind of a little bit boundless too. So now you've got people who have some special relationship with this person, or they believe they did, and they are unhappy about something that happened at the service or something. So, Representative Flores, now to get more directly, yes, the bill, in order to deal with that Supreme Court decision and to deal with what's going on with the abuses of the Supreme Court decision, the bill does talk about more than flowers. It does address, indeed, mishandling the body, which can include some things that you might be kind of unhappy about, right? You've got to deal with it. In order to deal with the problem, you have to deal with the entire picture and then try to limit what the mishandling of the body lawsuit looks like. And that's what this bill is trying to do, is to say, you know, mishandling the body lawsuit really looks like you cremated the wrong body and it was your fault. Not that you cremated the wrong body and it was somebody else's fault. It's that you did it and it was your fault. Or, you know, whatever else might have happened. So this bill is trying to put a box around what mishandling the body means, so that it doesn't mean I'm upset about the flowers. It means something that we all would agree was this entity didn't do the right thing with this body and therefore have some responsibility. And then it's trying to define to some extent what mental anguish means and who it is that can be the special relationship. So the bill is trying to take the Supreme Court decision and put it in some parameters that make sense for this industry. And then, yes, it's got liability limits built into it too, because in a lot of ways you feel like you kind of have to have that built into it, but that's a matter of policy for you all to decide. But that's what's going on with this bill, is to try to take the Supreme Court's decision and fairly narrowly say, here's what our box is when the Supreme Court's saying special relationship mishandling of the body. And it's trying to, the thing it does not do, importantly, as Representative Hayes said, is if the funeral home said, I'm selling you a solid walnut casket, and it turns out it's fiberboard, that's going to be a DTPA action, and this bill is trying to exclude that. So that is not mishandling the body, that's a DTPA action. So this bill is trying to take that out. If at the funeral service, someone, bystanders there attending the funeral, and they're hit by the funeral company's forklift, then that's a negligence action, and this bill is trying to take that out too. So the bill is trying to take out the things that I think we will all agree shouldn't be, should be actionable under existing common law or statutory law of Texas, and then draw this box around the idea of mishandling the body for mental anguish because you have a special relationship.
All right, thank you, Lee. Members, questions for Mr. Parsley? Okay. Thank you for the testimony. Appreciate each of you for being here. You can go. We've got one more panel. The chair calls Charlie Yen, Michael Soper, and Kristen Tips. Charlie, I'll start with you on behalf of I've got you here on behalf of the Texas Trial Lawyer Association and yourself testifying against the bill. Is that correct?
Yes. Good morning, Mr. Chair, Madam Vice Chair, the committee. I want to start by thanking Representative Hayes for speaking with us about this bill. We always appreciate the opportunity to collaborate. Representative Schofield asked the question, and Mr. Parsley just touched on it. What is this bill about? And it is absolutely about mishandling the body. And you know that because when we go to the bill itself, the first three parts of the definition, rather 3 out of the 4 parts of the definition, talk about retrieving, loading, and transporting the body, storing, embalming, dressing, casking, cremating the body, arranging, supervising, and implementing the final disposition of the body. And it's only on Part C that it talks about arranging, supervising, and conducting a funeral ceremony. I don't think that anyone has a rational argument to make about complaining about flowers. I don't think that's what this bill is, and I don't think that's what this bill does. Representative Flores, like you, my family owned and built a funeral home when I was younger in our small town in Texas. And what I will tell you is I saw what probably many of us see when we go to a funeral, that it's an opportunity for maybe a celebration or for mourning, or depending on your level of faith, maybe closure. But it's important, and we trust those with licenses, we trust those with certifications to take care of our loved ones and our family members. And Representative Hayes mentioned in his comments a few minutes ago 2 cases, one where a body in 2018 was lost. We don't know, today, we don't know where it is. It's gone. In 2025 of this year, an urn and the remains of a loved one were destroyed completely by an excavator. And then between 6 and 8 years ago in San Antonio, and the reason I say San Antonio is because it matters with the weather, Representative LaHood, as I'm sure you're familiar with the heat, a body of a loved one was placed in a casket and put in the back of a hearse, and it was left there. And when they opened the casket, the body had liquefied. Those are the types of cases that we're talking about, and the reason that's significant is because when you cap these types of damages, right, at $50,000 or 3 times the amount of the funeral cost, whichever is less, right, and the average cost of a funeral in Texas is roughly $10,000, right? When you cap it at that, or in the DTPA Act, like we were talking about earlier, the standard on that is a intentionally or knowingly. So if someone, and heaven forbid this ever happens, but let's say someone, let's say a plaintiff or a victim had evidence that a member of that funeral home said, I'm going to defile your body, intentionally and knowingly, your family's body. Cutting out the mental anguish on that, it seems unfair because of that standard of the DTPA being so high of intentionally and knowingly, not negligently, not recklessly. I intend to do this. When you look, though, at the caps of 50, if you're going to pursue this claim under the general negligence theory, or as the Supreme Court kind of carved this out for mental anguish, which is the majority and the main part of a damage model on a case like this, it doesn't come close to holding accountable the people that we trust to take care of our loved ones. And you see that, and you can tell that this is not just about flowers, it's not about music selection, because you look at what this bill does with the mental anguish definition. A typical mental anguish definition is, and I won't read it verbatim, but it's a substantial, general angst or worry. In this definition, it's a grievous, debilitating angst. It's a heightened standard. I know of no cases where there has been a suit filed because someone had a debilitating angst, a torment, needing to seek out care because of a flower choice or a song choice or the funeral proceeding not starting on time. But I do know how my family would feel if, again, like you said, Representative Schofield, if the body was dropped, defiled, melted, is gone forever. The lesser of $50,000 or times 3 of that average $10,000 funeral doesn't seem to me to give you enough accountability to enforce that. I'll be happy to answer any questions. Thank you again for the opportunity to testify in front of the hearing.
Okay. Members, any questions? Vice Chair Hayes, did you have one? Did you have a question? Okay. All right. Chair calls, do you have one, Chairman?
Well, you can go on.
Let's go. Okay. All right. Chair calls Michael Soper. Michael, I've got you here. Am I saying your last name right?
Yes, Soper.
All right.
Yes.
I've got you here on behalf of the Texas Funeral Directors Association and yourself registered for the bill. Is that correct?
Yes, sir.
Okay, go ahead.
Thank you, Chairman. Michael Soper, Houston, Texas, representing the Texas Funeral Directors Association today. We have 800 members. We've been an association in Texas since 1886. Most of our members are small businesses, just like we've been talking about. And I represent myself. I own a company called Legacy Funeral Group, and we have locations around the state, mostly in small towns, mostly very rural. So I feel like I can talk to some of the abuse that we've seen with some of the lawsuits as a small business owner. Basically, there are 3 different areas that create as conflicts. Most of the times, most of the lawsuits that we've seen are family members themselves that are arguing with each other, and the funeral home gets drawn in the middle of it and gets wrapped up into it, and we get sued. And we have no control over family members disagreeing with each other, either the disposition of the human remains or the way the funeral's actually put on. And the best thing we can do, and we're not investigators, is deal with the next of kin, who we feel is the person that legally should make those decisions. And then if we find out later, a couple weeks later, someone else shows up and says, I'm actually next of kin, then we get drawn into a lawsuit. And we see that over and over and over again. People will come in and make arrangements and say they've lived with this person for 20 years, and then the kids will show up and say, that was just a boyfriend. And we've made arrangements, and then we get drawn into a lawsuit because the person that actually was caring for this person, living with this person forever, has made decisions most of the time on how the deceased wanted the funeral to happen, whether it be cremation or whether it be burial. And then a kid shows up that hadn't seen the parents in 10 years and wants money. And so we get drawn in. And so this happens a lot. And as small business owners, we can't deal with that. And I'll specifically speak to out West Texas. And you know West Texas, they're small towns and they're spread apart. If you lose a funeral home in Fort Stockton, Texas, you're gonna have to drive to Odessa or Pecos to see your local funeral home. And that's what's gonna happen. That's what's gonna happen. Most of us have insurance, but like was said earlier, We're one lawsuit away from losing our insurance. And we don't want to lose our local funeral homes. They're caregivers, they're pillars in the community. They give back, they support the local schools, they do covered dish, and people are not coming to this profession because of these lawsuits and because of the abuse. And so we as business people need to get together and come up with something that's reasonable so that these people will still serve in these communities, in these small towns. And that's what our plea is. Basically, the other things that we as operators get sued is the condition of the body. This bill will address that the condition of the body that we received, we're not responsible for that. Sometimes grandma was in hospice for 2 months and she sat in a hospital bed. We can't control what she's gonna look like a week from now. We can't make her look like she's 20 years younger, and we get sued for that. And it's a shame. In both these situations, I've been sued for as a business owner, and I have members in our organization that have been sued for it over and over and over again. It's easy money for the plaintiff bar, and I hate to say it that way, but it is, and it's putting small businesses out. The third and final situation is property, and this bill can address that. Another situation where I got jewelry that all of a sudden came up missing, and we find out later it's actually the family. The deceased is in the casket. This happened in Abilene, Texas, in my funeral home out in West Texas. The body's in the casket there, and we're having a visitation, and grandma had jewelry on. The jewelry comes missing. Guess who gets sued? I get sued. It dragged on for almost 2 years, and we're convinced it was one of the family members that didn't get the jewelry, that wanted the jewelry. These kind of things happen, and they need to be addressed, and limits need to be placed on these things. And so that's my position. I'm passionate about it, as you can see. I'm passionate about small business. I'm passionate about the state, and I'm passionate about the care that we give families, mostly in rural communities. And I'd love to answer any questions, Chairman.
Thank you, Mr. Soper, for your testimony. Members, any questions for the witness? Okay. Chair calls Kristen Tips. Kristen, I have you here on behalf of yourself as a funeral director registered for the bill. Is that correct?
Yes, sir.
Okay.
Yes, good afternoon, Chairman Leach, Vice Chair Johnson, members, and thank you all for your service to the state of Texas and also for the opportunity to testify today. My name is Kristen Tips. I am the presiding officer of the Texas Funeral Service Commission, but today I am testifying on behalf of myself as a funeral director working with Mission Park, a fifth-generation family-owned funeral provider. And I think you've heard a lot of really great testimony, and what we have seen is that family-owned funeral homes, small funeral homes, mom-and-pop funeral homes are closing. Some across the state in the last 12 months have filed Chapter 7. And funeral directors are essential to public health and the well-being of the community. They are also known and recognized as the last responders, just like a first responder, just as important, but the last responders, the ones that were there during the pandemic that were absolutely essential and did a fantastic job in Texas managing the COVID-19 pandemic, coming to work no matter what. I mean, they had to come, put on their PPE, be there to care for families, help them navigate a day-to-day change in what the regulations were going to be on how many people could come and grieve together. Funeral directors have been essential to communities and to people for hundreds and hundreds of years. And everybody that deals with dead human remains, like anatomical facilities, medical examiners, law enforcement, JPs, non-anatomical donation organizations, municipal cemeteries, state cemeteries, they all have immunity. So when a medical examiner, and this is a real example out of Houston, Texas, switched the tags by accident, the medical examiner's job is to positively identify someone, releases the remains to the funeral home. The funeral home has the family identify. They say, yes, that's my dad. The funeral director does the cremation. 2 days later, he gets a phone call from the medical examiner from Harris County, and he says, do you have Mr. Jones? I'll use that name for now. And he said, yes, sir, I do. delivering him to the family. He said, "Oh no, I gave you the wrong body." The family of the person that was cremated sued the funeral home because they couldn't sue the medical examiner. No one else that has the body pre-existing to a funeral home can be sued. They all have immunity. So they sued the funeral director. The funeral director ends up in the news. The stories are he cremated the wrong body, and it just ruins public trust when it's not factual. But that lawsuit, that becomes a lawsuit, and there is another settlement. Hence, the premiums on funeral homes have risen over 8 years, more than 1,000%. There's 40% of funeral homes that can't get insurance at all. And the last thing we want are funeral homes out there without insurance. Funeral establishments and funeral directors are held at a very high standard through the Texas Funeral Service Commission, through the Federal Trade Commission. They don't have to have something that's so unbelievable in the verdict that they feel punished. They could lose their license. They could go out of business. They could also go to jail for actions that they do for their licenses. And we're down to 4 mortuary schools in our great big state. And in our interest in coming into our profession is not growing with our population. It is just diminishing. And I am just saying to please consider this bill and consider what it takes for it to work for everyone. These people answer the call of duty. They are doing the Lord's work 24/7, 365, and 366 on leap year. They get up from their dinner table because they got a call and they answer to another person, to a family that needs them. They are there to help people. They are not there to cause harm. They want to help. And we want to do something that could be reasonable so that mom and pops can stay in business all over Texas to be there to answer the call of duty for families that need to be served.
Thank you, Ms. Tibbs.
Yes, ma'am.
Appreciate your
Sir.
testimony. Members, Chairman Dutton.
Thank you, Mr. Chairman. I was going to ask, in addition to the definition of mishandling of the body, there's an "and" here that says, "and a reasonable person in the position of the funeral service provider would have foreseen in the mishandling." Tell me what that means.
Well, I'm glad you asked that question. I think that a lot of the several points that I've heard today talk about the 3 main causes of these lawsuits in which this bill certainly addresses that would prevent this from happening, and I think that's okay. When we talk about family conflicts, this is talking about a funeral association problem, right? The family-on-family conflicts, this bill would cure that. Again, there are things about this bill that I think are certainly workable, and I cannot stress enough how much we appreciate Representative Hayes talking to us about this bill and looking forward to working with him some more on this. What's not workable on this, Mr. Chairman, is the caps. Because the caps assume that this is about a flower arrangement or a delay in the start time. What's not workable is that when you have these terrible things that happen to loved ones that leave, again, when you go back to that middle anguish definition, right, the grievous, debilitating angst, distress, torment, emotionally suffering, a substantial disruption in the claimant's daily routine. That definition, right, cures that. But what the caps do is they take that substantial disruption and they limit it to the lesser of $50,000. That's the main concern. And then again with the DTPA, where you eliminate the intentional and knowing acts from mental anguish, it excludes that.
Well, given that, would making all this subject to the Texas Tort Claims Act work?
No, because I think the Texas Tort Claims Act is its own animal. I will admit to not being an expert in that area. I'll let other smarter, better lawyers than me deal with those claims. But what I will tell you about the TTCA is that it's designed to protect government. It's designed to protect municipalities. It is not designed to protect private entities. And let me just tell you, I believe that local funeral homes are essential to what we do. I think that they care more than probably big conglomerates. I think that's a good thing. But But I do think that doesn't mean they get to avoid any and all accountability when a body goes missing for 6 years. I think there's a distinction there, right? And I think that the TTCA is not a good fit for this, both in terms of cap and in what it's designed to do.
And I was going to ask you too, what we heard testimony earlier was that the contemplation of lawsuits resulted in prices charged. Is that true for you all as well?
What was the, I'm sorry, sir, will you repeat your question, please?
My question is, we heard testimony earlier that when there's a contemplation of lawsuits involved from a service provider, that they generally factor that into the cost of services.
Well, it eventually will. It has to at some point, because when the premiums increase, when a funeral home has to evaluate their prices for having their funeral home open, which would be the first line item on their price list, that's their overhead and any of the costs for the funeral provider. So it could ultimately do that, or if you have a large corporation conglomerate that's purchasing, then communities will be left with much higher prices on funeral services.
And so for many of y'all, like out in West Texas, you don't really have a lot of competition, do you?
It depends on the size of the town, sir. There may be one other competitor, but in most of the towns that are smaller, no, sir, we're it.
You're it, so,
Yeah, so it's a situation, as I'd mentioned earlier, some of these places are gonna close up, and we hate it. And we're already fighting the next generation not wanting to come into the business. And this is one of the reasons for it, so, thank you for your question.
and you're saying that they would close up because you can't put
Can't afford
into
it.
the price of your service
Yeah,
the cost of the lawsuits?
that's correct.
Okay.
And the cost of insurance and everything's gone up.
Right.
And it's hard to pass those expenses on to customers. With a lot of products and services that we buy, we can easily pass those things on, but in the funeral business, we haven't. If you look at the cost of funerals across the board, they're actually coming down. And so, especially with the on-site of a lot of cremation. So there's not the ability for us to turn around and charge. There's a point of diminishing returns at which the business will close. And that's what we're really concerned about with some of TFDA's smaller members.
And so the cost of the service that you're providing
Yes, sir.
is, well, let me ask you this way. How many lawsuits have you had in the last year?
I would have to pull our membership and see, but I think it would make your head spin. And a lot of them, not.
What does that mean?
No offense, but a lot of them are nuisance suits that go away. They're trying to find out what the deductible is on the policy and get that amount. And then meanwhile, you've spent twice that on legal fees. And as a small business person, all of a sudden, if you, I'm blessed to have a little larger business, but if you all of a sudden have $100,000 in legal fees, it'll crush you. It'll crush you not
Well,
just for
that's why
1
I'm
year,
curious.
but for 2
I'm
or
coming
3.
to cut you off, but
Oh, I'm sorry.
in the interest of time, I was just curious as to whether or not it was 1 or 1,000
Oh.
lawsuits that you had.
I would have to pull our membership. Kristen, would you like to, in your business?
Well, you said in the membership.
I have no idea with the membership how many lawsuits there are, but I could try to find that out. I know in my organization, we get them all the time, sir, especially in certain regions of the state where there's more abuse.
Well, I'd just be curious as to know the number of lawsuits.
Sure.
Because
Yes, sir.
I certainly can be respective of the problems that funeral homes face, but I don't want to jump in trying to decide a cure that's worse than the problem.
Yes, sir.
Okay, thank you.
Thank you.
Members, yeah, Representative Levitt. Sure, yeah, absolutely.
Okay. Thank you, Chairman. I kind of reiterate, or I tend to agree with Mrs. Tips on, I do think that government has some core functions, right, to keep us safe, provide for us while we're alive, but then what do we do when we die? I mean, it is a health hazard. And I'm just, while you are talking, I'm thinking, I'm Googling, in 2021, according to the statistics, 267,651 Texans died. In 2023, 232,995 Texans died. And I'm conflicted because Texas, the state, has not just an interest, but I believe a duty. And I think funeral homes and handling of our dead falls within that. I mean, without trying to go into history, wasn't the Black Death spread because of not disposing of bodies and whatnot? And so I guess my concern is this, is it sounds like, for whatever reason, funeral homes are in danger of declining. Like kind of analogy is, we're already undermanned. I mean, I know it's not a one-for-one with people living, but like as of right now, I think it's one funeral home for every 27,700 people. If we lose 100 funeral homes, it goes up to 31,300. If we lose another 100, it goes up to almost 35,000. And I guess my general question would be this, is that if certain core functions of the government have protections, why wouldn't funeral homes, and I guess it applies to everybody, but why wouldn't that apply to the final duty of the state or the final interest of the state?
Well, I would say this. I would say, while death and taxes are certainly two things that the government cares about, I think that death is typically a private, it's licensed by the government, right? And I don't want to hold myself out as a funeral home expert. That's not what I do, Representative. But what I would say is they're licensed by the state. They're just like you and I have a law license, right? But I think if you turn that over to the state, you're taking an entity that's private, that with supply and demand, and we can talk about the reasons for insurance costs are rising and maybe why court reporters, that's a particular occupation that's going down. We can look beyond this, but I don't think it's because there are lawsuits that are happening. I can look into that and answer you, but what I would tell you, I guess, for my base answer to your question is this. Funeral homes are tied to the communities typically that they're with, right? And I do agree that funeral homes can be pillars in that community. I think that if you went beyond the licensing and control in that area with the government, I think that would be overreach, in my opinion. I do.
And I respect your opinion. I'm just thinking as a core, I mean, whether the government does it through the government, it has a core need for it to prevent public health crisis, disease, all that nastiness. And, you know, we've heard testimony the last couple of weeks on same kind of pattern, right? Usually mom and pop businesses are on the brink of going bankrupt because of unregulated lawsuits, insurance, things to that effect. And so, and I don't know if the answer is true or not, but it sounds like a lot of the core function of the government has protections. I personally believe this is, maybe even if the government's not exercising it, it is of such an interest to the government, there should be some protections applied to it, because if we start losing, you know, if there's 1,128 funeral homes, more or less, and there's 254 counties in Texas, that means that every county has 4.4. I know San Antonio has, I don't know, a lot more than 4.4. I bet Dallas, Houston, I mean,
right.
A lot of these bigger cities or metropolitan areas are eating that up, which means pretty quickly we're going to get to counties that probably don't have a funeral home. And I don't know for a fact, I'm just doing pure mathematics.
Sure. I would tell you that I think that's a potentially slippery slope. I think that the role of government in our everyday life is important, right? I'm so grateful you're all here. But I think
you say that now.
Right, I do, right. I think, though, that it's just like anything else. I think government reaching into our day-to-day lives is good with guardrails. And I think that your question, I think, gets us into a different bill. I think for this bill, when we're talking about private businesses, insurance, funeral homes, and why insurance is going up or not, which I think is really a separate issue. I think we're talking about what are these private businesses doing and how can we hold them accountable and regulate in a way that's fair.
Well, I'll tell you this, full disclosure, I don't have my mind made up, but I welcome to give me information. I mean, and I'm no expert, I believe this is a core function of the government, or I don't know what the correct legal term is or whatnot, but I believe handling of the dead is of vital interest to our state. And I welcome information or conversations in my office, further that, but that's kind of where my mindset is at.
I'd look forward to it. Thank you, Representative.
Members, other questions for the witnesses? Okay, thanks to each of you.
Thank you.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 4101? Seeing none, the chair recognizes Vice Chair Hayes to close on the bill.
Thank you, Mr. Chairman. I do appreciate Mr. Ginn's kind words that I was willing to talk to him. I guess so few people want to talk to TTLA. They're so excited when someone will. That's just a joke. All right. Look, this bill, in any lawsuit, we have two things, liability and we have damages. And in regards to liability, what this bill provides.
Hang on, Vice Chair Hayes. Hold on. Is there one more witness? Did someone register who?
I'm sorry.
Hang on just a sec.
Oh, yes, sir.
Hold on. Coming up. Vice Chair Hayes, hold on just a sec. Go ahead, come up here.
Do you?
Yes, I'm sorry. Yes, come up here. Okay, Vice Chair Hayes, I'm going to reopen public testimony on the bill so that this gentleman can testify. Take your time, sir, it's fine. And if anyone else wishes to testify on, for, or against House Bill 4101, please come on up.
You see how your thing is moving up there? Mine is green. I was clicking around a while ago. And if you click on this, it gives you current view, list view, log out of chair view. I logged into chair view.
My sister's family was in the business for 100 years. They didn't grow. Lost it, they didn't grow. And she never had one lost it. Our Amy's family did because she was careful.
Anyway, I'm in the chair view and you're in the regular view.
Oh, you know, the chair view?
Yeah.
How do you get that?
Well, click on that little blue man up there on the podium. And then it gives you choices.
What's the difference?
I don't know.
Oh, the total registered members? Oh, was I in public comment? No. Totally just. Turns back blue. It just doesn't tell you how many people are registered, remaining and all that.
1, 2, 3, 4, 5, 6.
I can see. I asked her earlier how many people are on the bill, and I didn't know that, but his thing says that. Well, I guess if the government is supposed to take care of dead bodies, then I guess they can go in the business of burying them. Maybe they ought to provide indemnification in cases like the Texas Department, whatever, criminal.
Okay, the chair recognizes Salvador, how do you say your last name?
Purchase.
Salvador Purchase. You're here on behalf of Purchase Funeral Homes and yourself. all the way from El Paso.
Correct.
I'm glad you stopped me.
Thank
Welcome,
you. I'm
welcome to the
glad.
No, thank you.
We had a bad sandstorm yesterday. and
I
I'm glad
understand,
made
I
it.
understand. We're glad you're here. Thank you for being here to
Thank you.
testify. I've got you registered for the bill. Is that correct?
Yes,
All right, go
correct.
ahead.
Okay, well, I'm second generation, and I'm so excited that my daughter, oldest daughter, 25 years old, just joined. So now it's third generation funeral homes in El Paso since 1958. I've always said we answer our phones since 1958 every day, and just like you heard, our hard work and my team and all my funeral directors are always so busy. Of course, through COVID in El Paso, we had the horrible situation of the Walmart situation. We took care of 13 families, and that was on us, and we wanted to give back to our community. And got together 22 hearses to make a point in our city and took all the flowers that we had on the last case of the families and took them to the Walmart area. And that's just a whole nother thing that I'm upset about of what's happening. But we're always on call. I understand, there can be certain cases or certain things. My insurance has gone up more than double in the past, say, 6 years. We take care also of the border. We do a lot of transfers also into Juarez and into the interior of Mexico. I went to funeral director school right in Dallas right after high school, and I love my profession. I love what I do. We do it with heart. We do it with passion. And it is getting difficult because of the situation, say, with insurances, with, we are human. All of my team is human, of course. And there could be a little mistake here and there, but we can't be punished so hard. I do believe in this, and I believe we can, come up with something that will help us.
Yeah, thank you. Great testimony. Thank you. Representative Flores.
You said your insurance has more than doubled. How many times have you been sued, for mishandling a body or something egregious like that? Any times?
I would say about 5 times maybe in the past 6 years, 7 years maybe. But what the insurance companies ask is for your lost runs and so on and so on. And it's not just to one funeral home. They kind of see it nationwide. And I go to all the conventions nationwide. I meet directors from every state. And it's not just a Texas problem. It's a nationwide problem that funeral homes, that we are having with insurance companies.
Okay, because I know, okay, well, thank you.
Members, other questions for the witness? Thanks for being here. Go ahead.
No, thank you so much for letting me in. Sorry for the mishap.
No worries at all. No worries at all. Thank you for, I'm glad you flagged us down, and thank you, Chairman Landgraf, for stopping me. So thanks for your testimony.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 4101? Seeing none, the chairman recognizes Vice Chair Hayes to close.
Thank you. Mr. Chairman, clearly, burial and the handling of the body is a very important event in a family's life. What this bill does is it clearly creates liability for mishandling the body. What it does do then is, what does it do to damages? And on page 4 of the bill, this under section 77A005, it says this chapter does not limit a claimant's recovery of other forms of economic or exemplary damages or apply to other actions, including actions to recover damages for death or physical injury caused to the claimant by negligence of a funeral service provider. What it does limit is mental anguish damages. Now, as the bill is written, it limits mental anguish damages to the lesser of 3 times the cost of funeral services or $50,000. The companion bill was considered by the Senate, I believe, just yesterday. It's there. What came out of that was a committee sub where they amended it, and the $50,000 was increased to $250,000. So I anticipate there will be a committee sub that I will bring forward on this, and I think that will improve the bill greatly as far as caps. But remember, no cap on actual damages. It's just on the mental anguish is what this bill does.
Sure.
With that said, I close.
Vice Chair Hayes, thank you for your work on this. I know you'll be committed to working with all sides to get this right. I'd like to see, if the information's readily attainable, what other states do in this area. This clearly can't just be a Texas problem. I'd like to see maybe if you've said you've been to conferences, and I know there's national associations, if there's any readily available resource that can show us what other states' laws are like in this area, I think would be interesting for the committee as well.
I'll see what I can find.
Thank you, Vice Chair. Members, any questions for the bill's author? All right. With that, the chair will leave House Bill 4101 pending at this time. Our final bill of the day, the chair lays out House Bill 1181 by Representative Raymond, and the chair recognizes Representative Schofield to explain the bill. I think.
Guess it would help if I turn my mic on.
Is that correct?
Yes, yes,
Okay.
sir. Thank you, Mr. Chairman, members. This is a simple bill. It also is a bill that was non-controversial in this committee. It passed out of this committee unanimously last session, passed the House on local, and was set to pass the Senate on local before, you may remember, things blew up and they pulled dozens of our bills off of their local calendar. Ever since the pandemic, there have been some backlogs in the courts that they're working to excise, and you can recall, Mr. Chairman, some of the testimony we heard in our first hearing about how the courts are working diligently to try to do that. One of the ways that they can do that is through getting visiting judges, retired judges who will come back and hear cases. What this bill will do is help make more of those visiting judges available by lowering the time that a judge had to serve before they could be eligible to be a visiting judge from 8 years to 6 years. The bill actually says 96 months to 72, but I had to do the math because I didn't know what that meant. But it will lower it from 8 years to 6 years. The judge would then agree not to obviously hear any cases involving clients or former clients of their law practice, and also not to practice in the courts that feed into the court that they are hearing cases in, if they're an appellate judge, or in the county where they are, if they are a trial judge. There were, back when we started, some witnesses signed up for this. I don't know that there still are, but if there are, I
see one of them here.
On Mr. Raymond's behalf, I would reserve the right to close.
Members, any questions for the bills, for Representative Schofield? Okay, seeing none, chair calls Judge Herman, Bryce Chapman, and Brandon Johnson. Is Mr. Johnson here? Are you Mr. Chapman? All right, come on up. Again, is Brandon Johnson here? All right. Seeing none, I've got him registered to testify on the bill, but wishing not present to testify. Mr. Chapman, I have you here on behalf of yourself, registered against the bill. Is that correct?
That's correct.
All right, go ahead.
Thank y'all for staying here for so long. Y'all have to be bored. Pertaining to this 1181, this is a personal note about retired judges. I've had a huge conflict, and I'm not here to mooch off the state. I just personally want to be left alone with my property, which involves a bunch of retired judges. I've had about 6 or 8 retired judges recused off of a family law case, where it started off where the judge was my wife's attorney. I have a constitutional disqualified judge, and I have a bunch of recused retired judges that will get off the case, but I can't get anybody to sign the motion to disqualify the original judge. And so these judicial disqualifications and special interests on some of these bench appointments for these retired judges, they need to be addressed. I'm personally involved with this litigation where the Chief Justice for the Amarillo Court of Appeals, he's retired now, his name is Brian Quinn, owns property in close proximity to mine, where he has appointed, or they have appointed 2 retired judges from that same in-bank panel of retired judges from the Amarillo Court of Appeals, Mackie Hancock and Patrick Pirtle. They ruled on my property to take my property based off of a void judgment. That's a little bit too close to home, with 3 people involved on the same exact matter in controversy where they took my property, where it's been unlawfully appropriated, and these are retired judges. This is kind of like Martha Stewart insider trading, to be honest with you. Shouldn't be done. Where this Brian Quinn stands to make millions of dollars off of a lake project with my property. I think that's wrong. And also, it's along with his personal friends who have bought my property for an investment, which they had no right to purchase in the first place. And these other retired judges that have been recused, I don't see that this bill changes the number from 96 to 72. It's not going to matter without accountability for current or appointed or retired judges. No change in a number on a piece of paper is going to change judicial rules or judicial financial interest or special interest in many cases. This case that I'm talking about with these appointed retired judges, on my specific case, this is willful criminal activity by those that are entrusted judges, and they're supposed to abide by it shouldn't be hard for them to abide by the law themselves. If ruling in one unwarranted fashion by retired judges is a current issue, then what kind of rulings or adjudications will happen with their younger replacements if precedent has any meaning at all? And to redress the grievances where they're not being addressed with no accountability. I'm from West Texas, where I thought integrity and honor were supposed to have merit. And it doesn't, obviously. So I'm not sure that I can even, there was a man in here that said a minute ago that there's a rule and run. Well, there's been 8 judges rule and run on my property. 3 of them on the same in-bank panel from the Amarillo Court of Appeals to steal my property. So retired or not, for them to use and abuse their position to seek personal gain by ill-gotten means without accountability or removal from office, these dates are not even going to be, those kind of months aren't even going to be needed. What I'm in disbelief is that this is even a topic of discussion amongst a bunch of well-educated men.
So, hey, Mr. Chapman, I thank you for being here and sharing your testimony and your story. If you could get to the bill and why you're specifically against the bill. We've got 2 other witnesses.
Well, like I say, no amount of time will cure misconduct. Reappointing these judges that come in, they with no accountability, and they just rule. They don't know all about the cases, and they don't study those cases to rule on them correctly. I don't see why, like I said, the amount of times appointed to this bill is going to do any good, because if there's nothing to hold them accountable for their actions,
Understand.
there's nothing that's going to help us,
Okay.
especially in my case.
Okay, thank you. Thanks for being here and sharing your testimony. Members, any questions for this witness? All right, now I encourage you, if you haven't already, to go visit the bill's author, Representative Raymond, and make sure he hears from you as well.
I will.
Okay. The chair calls, Mr. Johnson, are you here? Okay, come on up. Chair calls Brandon Johnson. Brandon, I've got you here registered on behalf of yourself on the bill. Is that correct?
Yes, sir.
Okay.
And I'm just on the bill because I don't know that it really matters one way or another. It looks like you're just adding some language. 6 years instead of 8 years. But again, this goes back to my theme for the whole day. We have no accountability in the judiciary, and here we're saying, well, they already want raises. I know that's not in this bill, but then you're saying, well, we're going to lower the standard from 8 years to 6 years. Well, most district judges are elected to 4-year terms. So now you're saying, well, the guy can get on and then retire halfway through his second term after he's been an attorney. That's a possibility. And then come on, get his retirement, and then make a day wage setting as a retired visiting judge. That's a double dip as well. The SCJC is toothless. Representative LaHood, you said that earlier. you're talking about toothless bills. I think it was you, and I may be mistaken, but it was somebody on this panel. No, well, you were talking, somebody was talking about toothless bills earlier, okay? Not specifically with the SCJC, but there is zero accountability in the judiciary, none. And then here we are in this bill, we're rewarding these judges. And on this bill, it talks about a willingness, where the judge has to say that he's willing, there's a willingness not to hear any matter involving a party where it was a client. And then that's mentioned a couple times.
Yeah.
Well, again, that's toothless. And I know that was already in part of the existing legislative language. But again, there's zero accountability for these judges. Thank you for your time.
Well, I want to encourage both of you guys, as I told Mr. Chapman, to go see the bill's author. Please,
Okay.
go see Representative Raymond and make sure he hears from you. Does anybody have questions for this witness? Seeing none, Chair calls Guy Herman. Judge Herman, I've got you here on behalf of the Statutory Probate Judges of Texas and yourself registered for the bill. Is that correct?
Yes, sir.
All right. Go ahead.
I am supporting this bill because we have a shortage of judges. These regional judges can ask me, as presiding statutory probate court judge, to send a statutory probate court judge to hear probate, funeral disputes, other kind of things, and I don't have judges to give them, and I want to give them judges if I can. I actually have another bill coming this way, filed by Senator Hughes. It's going to allow not only statutory probate court judges to hear statutory probate type cases, but to let appellate judges who have 72 months service, much like this bill, serve for us. And just wanted to bring that to your attention. Also, you were asking a question about the funeral business, 711.002. There's a priority scale. Who gets to do that? There are disputes about, I'm not into the damage business, all that's none of my business.
Well, are you on this bill or another bill?
I was just telling you, you had
Well,
asked a
you
question. I'm
just,
sorry.
I
I'll let you
understand,
go.
but I got to keep you on this bill, Judge.
Okay. But anyway, we support this bill. We voted to support it.
Okay.
I need it to do my job as presiding statute.
Thank you. Thanks for sticking around, Judge. Members, any questions for Judge Herman? Yeah, Representative LaHood.
Thank you, Judge. I love the bill. I just have one question and concern. I want to know if you have any concerns. There's a caveat for private reprimand, including if they resign with a private reprimand. I've never been a judge. That concerns me. I don't know how those things happen. You know, maybe it's a formality. I have no idea. Do you have any concerns with a reprimanded judge, even to the point of resigning because of it, being allowed to now be appointed?
Well, I don't read the bill that way. I read the bill slightly differently, that if you have had a public reprimand.
Public, yes.
You can't serve. And then private reprimands can be using a curse word in it.
Well, that's why I was asking. I've never been a judge, so I don't know what the judicial conduct rules and ethics rules. So I have no idea. Maybe the private ones are reserved. That's why I'm asking you, because
They're for minor transgressions, and many of them say you got a private reprimand, you need to go to some more educational courses. You need to do this. Don't curse anymore, if that's what was the issue was.
Thank you.
All right. Yeah, Chairman Landgraf.
Thank you, Mr. Chairman. I think, when we were discussing this a little bit earlier, and in rereading that subsection 2 on page 2, that applies if the justice or judge did resign under circumstances described in subparagraph 1, but the judge or justice was not publicly reprimanded or censured. Does that indicate in a disciplinary proceeding that there was just a resignation, but then there was not subsequently?
There have been judges that there is a grievance filed on, and they just resign and say, I don't want to deal with this anymore. Some of those may have been a claim that should be a private reprimand. Some of them could be a public reprimand. Some of them, I mean, there's I know of a judge who was convicted of income tax fraud.
Yeah.
So he resigned. And
But that wouldn't necessarily be followed up with a subsequent
no, they would never be
public
able to
censure
serve.
or other public act against the judge. Okay. Thank you, Mr. Chairman.
Thank you, Chairman. Members, any other questions for Judge Herman? Okay. Seeing none, does anyone else wish to testify? Thank you, Judge. Does anyone else wish to testify on, for, or against House Bill 1181? Seeing none, Chair recognizes Representative Schofield to close on the bill.
On behalf of Representative Raymond, I ask for your favorable consideration, and I close.
Okay, members, any questions for Representative Schofield? Seeing none, the chair will leave House Bill 1181 pending at this time. A reminder, members, we're going to hold a formal committee meeting tomorrow morning at 9:30 in the Ag Museum to vote on pending business, 9:30 tomorrow morning. That concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair.